Are there any housekeeping matters that we need to address this morning?
Start the recording now.
Thank you.
On the assumption that we're going to be having a discussion towards the end of the day, we can access the requirements.
Good morning. Good evening. Can you hear us?
Sure, yes, I can. Thank you.
Yep. Welcome. Appreciate you talking to us.
Oh, thank you so much for letting me join from overseas. It's very much appreciated. It's an important hearing for us, so it's nice to have the opportunity to speak to the submission.
We're in your hands, but we have read it, but we're in your hands as to how you wish to present this morning, whether you wish to summarise it or identify some key points or.
Yeah, I've just got a quick summary of the submission, if that's okay. It won't take very long.
No, that's much appreciated. Thank you.
I just need to apologise. I haven't seen any of yesterday's hearing, so apologies if I repeat things that may have already been resolved. I just unfortunately haven't been able to hear them through the night, and I've also quite quickly had to look at the joint witness statements as well. So apologies if I've missed anything in those as I go through. I've just made a couple of quick comments. So this submission is made on behalf of the Runanga. The applicant site lies solely within the takiwara of Ngāti Waewae, so they're the only Runanga that need to be involved. And Ngāti Waewae have asked me to thank the applicant and particularly their consultants for the consultation that they've undertaken with us. Ngāti Waewae has particularly appreciated the ability to visit the site and to understand the landfill operation and to see the local environment. So I thank you for that. Just a quick note on the Grey District Council community drinking water supplies. So Ngāti Waewae is aware that GDC have concerns about the impact of the proposed discharge on their community drinking water supply. The Runanga considered that as the owners of the community drinking water supply that GDC were the most appropriate party to raise these concerns, and hence these aren't detailed in the Runanga's submission. I just wanted to highlight that point. What the Runanga did want to highlight in their submission is that all water as a taonga is a treasure to them, and they're concerned about the potential for adverse effects from the proposal on all water, not just on water that's needed for community drinking water supply purposes, even though that is important. So it's the mauri of the life supporting capacity of water that is important to them and is why they've submitted. Just a few points I wanted to make from the submission that are just at the beginning of their submission in relation to some process matters. I think they've already been highlighted to you from the looks of the minutes. The first matter was the scope of the change of conditions application. In the submission, Ngāti Waewae just wanted to highlight that they've never really been involved in a change of condition type application like this. They don't have a set position on it. And how the legal side of that works, but they just wanted to ask me to emphasise to you that they did have great comfort with the existing wording of condition 11, which effectively prohibits the contamination of surface water and groundwater beyond the site. And the other process matter that they raised, which was again just a query as to limited versus full public notification of the applications. And this query came up when GDC started to share their technical review of the application that their technical experts PDP did during the submission period. and the Runanga wondered if, could just questioned if the adverse effects of the proposal on the receiving environment were deemed to be, or determined to be more than minor, whether limited notification was appropriate or whether it should have changed to full public notification. But again, they don't have a position on that, but they just were querying that. And they wanted to advise the hearing panel that if it had been publicly notified, then their iwi authority would have joined their submission, and it would have been a joint submission between the Runanga and their iwi authority. Just moving on. So the general position and the reasons for the submission. Ngāti Waewae have the kaitiaki responsibilities to manage, protect and enhance if degraded natural resources within their takiwā. In saying that, they wished me to emphasise that they are supportive of new and ongoing developments within their takiwā, provided that these activities are undertaken in a way that respects the environment and doesn't adversely affect their cultural values, rights and interests, particularly around their ancestral land and water. But they also are aware that infrastructure, particularly for the disposal of waste, is something that the region needs, and that waste generated within the region should be treated and disposed of within the region. And that was particularly important to them.
Is that for cultural reasons? Is that for cultural reasons?
Not for cultural reasons. It's just a point of principle that like if we're generating that waste within the region, we shouldn't be taking that waste and putting it in somebody else's takiwā. We should, as a region, be looking after that waste and dealing with it within our region.
Thank you.
Yeah, they certainly wouldn't advocate for taking waste and putting it in another Runanga's takiwā. They may not be popular for that.
Thank you.
In terms of the submission, one of their main concerns that they talked about was about the adequacy of the information and the assessments. This has really come from the fact that both the West Coast Regional Council and Grey District Council engaged technical experts to peer review the technical information within the application, and the Runanga got to see that information during the submission period. So we really, the Runanga relied on that information, and they were concerned about the reliability of the conclusions reached in the AEE if there were some information gaps. So they, in their submission, they wanted to highlight the fact that they really wanted to see a robust assessment of effects, and they've been pleased to see the caucusing of the technical experts. I won't go through all of the matters of concern, but they're all listed in their submission. Since we've seen the recently circulated joint witness statements, particularly the one for hydrogeology, we've seen that some of the technical matters seem to be have been addressed, but there also are still some important matters of disagreement between the technical experts, and that is still of concern for the Runanga. There's paragraph 12 of the joint witness statement talked about there's still agreement between the experts that all of the potential contaminants of concern for the site haven't been tested for in the discharge, or sampled within, looked for in the groundwater or the surface water, and that the experts are saying that those things need to be established before the discharge occurs. And they're also concerned about the points of disagreement between the experts associated with how the discharge is going to leave the site. They did note in the joint witness statement, and they wanted me to express to you that they saw that the participants to the experts were agreed that in theory that it was feasible to manage the proposed discharge via discharge management and response plan consent condition. And the Runanga considered that this plan needed to be informed by further investigations and subject to independent review. And if this approach was progressed after some of the caucusing, particularly with the planning condition writers, that they would be interested in seeing that draft condition wording and commenting on that for the panel if that was deemed appropriate. They were also we also had a look at the joint witness statement for ecology, and we noted that there was a shared position by those ecologists that they actually, before they could do their full assessment, they needed to see a joint sort of position or shared position from the groundwater experts, and that would impact their assessments. Surface water is of particular concern to the Runanga, so they would support further caucusing of those ecologists and for an updated joint witness statement to be circulated in due course if the hearing panel deemed that was appropriate. They noted that in the joint witness statement that both the ecologists supported monitoring of surface water bodies, and that was something that the Runanga are definitely supportive of. The other key point in the submission related to the evaluation of alternatives. We realised that it's an urgent application. The applicant needs to create freeboard, and so that we don't have this discharge occurring. What the Runanga has covered in their submission is they'd really like to understand whether there were sort of further improvements that could be made to the site in relation to the design that could help with reducing the amount of stormwater that was going into those ponds, whether there's some way of sort of minimising rainfall. They're not experts in those matters, but they were just keen to see if those matters had been considered. They were also keen to understand whether the proposed treatment system, how that compared with best practice elsewhere. And they were encouraging the applicant to investigate additional leachate treatment methods to try and ensure the highest standard before discharge. The idea of using water to dilute wasn't supported. The more that can be treated before the discharge would be appreciated. And also in terms of looking at alternatives while discharge to land is supported, whether there was the potential, if it was suitable, to discharge or irrigate the leachate onto the land so it was spread over a wider area, so there was more contact as opposed to the more concentrated soakage pit system, or whether there were opportunities to be able to treat the leachate to a certain standard where it could be reused for an alternative purpose. Again, they're not experts in those areas, just things that they were keen to highlight. In relation, just quickly before I finish, in relation to conditions, we noticed in the section 42 officers report in paragraph 219, they talk about the potential for a bond. I'm not sure, I wasn't able to see whether the applicant had proposed a bond. I noticed that the officer provides advice to the hearing panel that if they were of the mind to grant consent, that further information advice should be sought on the suitability of a bond, its duration, its value, before a decision. And the Runanga would support further information advice being provided on this matter. They're not sure if it's appropriate, but yeah, would like it to be sort of teased out further. Finally, in their submission, the Runanga requested the opportunity to work with both the applicant and the council in the drafting of consent conditions. I think things have probably moved on a little bit from there, but if caucusing of consent conditions occurs after that, the Runanga would appreciate the opportunity to comment on any caucus consent conditions if the hearing panel was acceptable to that idea. And I think that's probably the summary of the submission and the points they'd asked me to make.
Thank you. So just on that last point, Ngāti Waewae doesn't wish to be involved in the caucusing process itself through experts.
We obviously haven't put up a planning expert or circulated evidence for the hearing, so we didn't know if it was appropriate to ask for that. We've certainly got planners who could be involved with condition caucusing if that was appropriate, but I wasn't sure whether that was something we could request, but we could certainly provide someone to be involved if that was okay. But obviously the technical sort of science monitoring conditions and things like that, we'd be relying on the expertise from the other people's experts.
But at the least, you also have the ability to comment on any further draft conditions before we get onto our decision-making process.
Yeah, if that was acceptable to you, we would appreciate that opportunity.
Okay.
Kia ora, Ms. Lynch.
Kia ora.
Look, thank you for that overview. One of the outcomes of your overview has been that you've addressed largely the questions that I may have had for you. So there's just one outstanding to me. You've commented on the process as you see it going forward and some really useful thoughts about that in terms of Ngāti Waewae's involvement in that. Would it be your perspective that at that point that Ngāti Waewae could review its position on opposition subject to all of those matters being addressed to Ngāti Waewae's satisfaction? Would that, because at the moment it's an opposed position, isn't it?
Yeah, and in our submission, usually, well, our experience to date is often consent conditions are drafted by the Section 42A officer and then by the applicant, and often we'll comment on those conditions before it gets to a hearing. And
yes,
at that point, we may reconsider, or the Runanga will often reconsider their position. In the last 3 or 4 hearings that I've been involved with, they have changed their position as a result of seeing a more finalised set of draft consent conditions. So I think they mention it. I think it's mentioned in the submission that they may reconsider their position, and I would expect that would be the case.
All right, thank you. Yeah, just thought I'd clarify that point. Thank you. And you've addressed all of the other matters, just with the additional comments that you made about some of your sort of objectives or thoughts about the joint witness, the caucusing, the joint witness statements. So thank you for that. So there's no further questions from me.
And a number of the matters that I raised have been addressed in your discussion as well, but I'm just interested in understanding if you can convey it, the preference for irrigation. Is that, and I'm probably putting it clumsily, but is that to enable the earth to essentially treat prior to it getting into the Y? Because if it goes straight in, it will, there's the greater impact on the moray of the river. Yeah,
and the Runanga is definitely no expert on how these things will work, particularly for leachate. So if that's, if the experts say that that's not a good option, then they're comfortable with that. They were more concerned. They like the idea of irrigating to land. One, you can have your plant uptake. Also, you're over a wider area, so it's not as constant. They just felt like the soakage pit was really concentrating the discharge into one point, whereas if it's discharged, irrigated to land like they see like dairy effluent, not that this is dairy effluent, then it's a wider area and you've got more contact with the earth. And a lower application rate.
Okay, thank you. And the other matters that you sort of touched on, but you did in the submission, some clearer information in terms of the suite of contaminants. That was an issue that was identified.
Yeah, that's really important for us. The history of the materials that have been taken by the site has really changed. Like originally it was just half hard fill, and then it's moved on, and then like we had the contaminated organic material from further up the island came down, and then there was coal tar, and we just felt that the suite of contaminants that we saw in the application, we weren't sure that that was consistent with everything that may be being received by the site. So we just wanted to make sure that that we really knew that everyone knew what the potential contaminants would be in the material being received, and then for monitoring purposes that everything being discharged was being captured, that needed to be captured. But again, we would be relying on the technical expertise of those hydrogeologists and chemists and others to tell us what those contaminants needed to be sampled.
And the same for the matter raised in the submission in terms of treatment. Same position. You want to make sure that the leachate is treated as well as it can be, if you like, before it's discharged.
Yeah, the treatment system has been designed, but we weren't sure if it's been designed based on the list of contaminants that are included in the application, or whether the treatment system also considered those other contaminants that haven't been listed, but we know are likely to be included within that material. So it was just a query to make sure that the treatment system selected for the site was the most appropriate for all of the contaminants and material that are likely to be disposed of at that site.
Okay. I was going to ask you about the public notification issue, which you have touched on briefly. In the submission, that's not emphasised, but it's raised as an issue. Were you looking at that from the perspective of the Resource Management Act, which provides that you can't grant a consent if it should have been publicly notified and wasn't? Are you raising it in that context?
I guess that's a very good point. We probably weren't raising it from that aspect. We were more just querying it as we started to draft the submission. The group that we work with within the Runanga were like, oh, we need the iwi authority to be part of our submission, and it's really important given what's going on here. And we were like, oh, actually we can't, normally we do, but we can't in this situation because it is limited notified. And then we had to have quite a discussion as to why was it limited and not public, given some of the concerns being raised. And we thought, oh, yeah, maybe that's something we just need to, we didn't have a set position on it, but we just wanted to make sure that those that do consider these matters were aware of that and went through those tests for us.
All right, well, that was all I had, and the submission was clear and your, talk has been very clear, so we really do appreciate you, taking the time to speak to us today. And we will
Oh,
be,
no.
we will be at the end of today, probably we'll be talking about the process here, that will also involve submitters as well as it moves forward.
Thank you. If there's anything further that you need from us at any point, please let us know. We're very keen to stay as involved as we can and work with the applicant where we can too.
Thank you. Thank you very
Okay.
much.
Thanks very much.
All right, good morning, welcome.
Good morning, Commissioners. On behalf of Grey District, thank you for the opportunity to provide a submission on behalf of the Council. I, with my colleague, Mr. Sylvester, will be presenting that submission. If we may do it on a joint basis, I'll essentially take the first half and he will take the second half. Grey District Council also wishes to thank all the parties, participants and their consultants for the information and participation both in the lead up to this hearing and yesterday. Grey District Council's submission is that the proposed consent applications should be declined. And there are 5 levels essentially to that submission. The first is simply that the applications contain inadequate information in order to determine the application and should therefore be declined pursuant to section 1046 of the Act. Second, the applications trigger prohibitions under the National Environmental Standards for Sources of Human Drinking Water regulations and section 107 of the Act. Third, even if the prohibitions are not triggered, the Commissioners should still decline the applications in their discretion because of the potential for significant adverse effects, including to the Grey District water supply. It's not only that, ecology is also a key. Fourth, even if the Commissioners are minded to grant the consents, there is insufficient information now to determine appropriate conditions such that would avoid, remedy or mitigate adverse effects. And if the conditions are not going to be sufficient from the outset, the applications should be declined. And finally, if despite that the consent is granted, conditions need to be stringent and cautious and avoid the risk to the Grey drinking water supply materialising and ecological effects. And Grey District Council comments in these submissions on what conditions would be required just as a minimum to enable compliance with its statutory obligations onto the water service.
Just before we move into the structure of your submissions, are you happy if I have questions that arise during the presentation?
Yes, yes. It may be that Mr. Sylvester, between us, may be answering them as part of it.
Thank you. So your paragraph 2.
Yes. So the structure of the submissions, first of all, is to set out in a brief way the key foundational legal principles that are engaged by the applications. Second, a summary of the evidence regarding effects upon Grey District water supply, and related to that, an analysis of the statutory and planning framework in relation to that water supply. Fourth, an analysis of the evidence and the statutory and planning framework regarding ecological effects. Fifth, Grey's submission in relation to potential conditions. And finally, some brief confirmation of the Council's position on alternatives. So in terms of the foundational legal principles, what is covered in these submissions is some brief commentary on what is the existing environment, the approach to risk and effects, and the precautionary principle or approach in the context of scientific uncertainty. Turning first to the establishment or understanding of what is the existing environment. For the purpose of these applications, this includes essentially the items that my friend outlined yesterday in open submissions, the site in question, adjacent waterways, roadside drains, the Grey River, its tributaries, the underlying gravels beneath the site and the groundwater, and the Grey District Council water treatment plant and bores. The existing condition of the surface and groundwater are included. And that perhaps requires some brief comment. And we have noted that Dr. Durant discusses the status of the existing environment in the Section 42A report at paragraph 74 in relation to what is an important question about the existence of pre-existing contamination by leachate at the site that may be mobilised off-site by the proposed discharge. And I will come to the factual discussion about that a little later on. But in terms of how that relates to the existing environment, this seemed to cause a little bit of difficulty in terms of whether that leachate in groundwater is part of the existing environment in a legal sense, particularly because condition 11, as we know, specifically prohibits contamination of soil or groundwater off the site. And Grey District Council's position is that any pre-existing contamination of groundwater, while it might not have been permitted in the sense of being permitted by a consent or a plan, it is part of the existing environment in a factual sense, and that is something that will need to be confronted as part of the consideration of these applications. Establishing the existing and predicting the future state of the environmental setting of a proposal requires a real-world approach, and it's not an exercise of discretion to avoid that. Such pre-existing contamination must also be considered alongside the contaminants that we know will be introduced by the proposed discharge. And that's part of assessing the actual and potential effects on the environment of allowing this activity under Section 104(1)A of the Act. And it is also, as Dr. Durant correctly points out, a matter that is relevant and reasonably necessary to have regard to in determining the application under Section 104(1)C.
Just on that point then, just so I'm clear with, I might be cutting you off, but just in terms of the existing environment, so in essence, is what you're submitting is that from a legal perspective, the contaminants which have been discharged are not part of the existing environment. It's when that's fluid and lower. But when we're assessing it, we need to acknowledge that they are there, and so look at whether there are cumulative effects or whatever.
Yes. Yes, that's right. It's pertinent to the issue of effects. And any questions about legality or whatever it might be, it's not of much because they are there, it seems, and it is something that has to be considered as part of the technical condition that the experts have been talking about earlier, and we'll hear more from Mr. Work from Duncan and Taylor.
Thank you. Paragraph 7.
Thank you. The combination of pre-existing contamination and the new contamination that will be introduced by the proposed discharge, together with the potential for mobilization that Dr. Durant identifies in his report, are additionally cumulative effects captured by Section 3.
That should have delayed my question.
Yes. And in relation to that, the Environment Group has guided us and said that if an existing activity has adverse effects and a proposed activity also has adverse effects, even if only minor, which would add to the existing, then the definition requires consideration of both. It would be an exception to the permitted baseline concept. It's not technically we're talking about here, but only to the extent that one could have regard to existing adverse effects when and only when taken together with the new effect, they produce a synergetic impact on the environment. Sufficient baseline testing of surface water and groundwater is required for this, as Mr. Work identifies, and which is understood now to be agreed as part of the joint witness statement. Turning now to effects and risk, we heard through the Applicants Council yesterday, the identification that the Resource Management Act is not a no-risk statute. Grey District Council, of course, accepts it, but it says that it is not a to-be-confirmed TBC statute. The RMA defines effect in Section 3 in a number of ways that the Commissioners will, of course, be familiar with, and they are reproduced there at paragraph 11.
Good, paragraph 12.
In terms of Section 3F, this is in relation to the potential effect of a low probability, which has a high potential impact. And that in reality is what we are talking about a lot here. There is some guidance on what that means in terms of the case law. In Shirley Primary School and Christchurch City Council, that level of potentiality was interpreted as a real risk, i.e. there had to be a real risk given weight in terms of the assessment. There's also useful guidance in the case of R.J. Davidson Family Trust and Marlborough District Council, and the High Court discussed the following approach in relation to the assessment of effects. Determining actual effects on the environment is relatively straightforward because it concerns existing factual circumstances that can be proved on the balance of probabilities. However, the authority must also take into account potential effects on the environment. The word potential denotes something other than proof and cannot be assessed on the balance of probabilities. Instead, it was appropriate to assess risk that carries less than a 50% chance of eventuality. And in that case, in particular, it was a discussion about the risk of species extinction. That was deemed to be much less than 50%. And it could not be proven that extinction was more likely than not to occur. But instead, it was appropriate to assess existing facts on the balance of probabilities and consider whether any particular evidence is proved to that standard. The assessment of potential effects then depends on an evaluation of all of the evidence, but does not depend on proving that potential effect will more likely than not occur. The court also said, the law requires that the authority or a court be satisfied on the balance of probabilities that the risk of some future event occurring is likely, albeit that it is a low probability event. That is not the same as requiring that the future event is proved on the balance of probabilities. And in that case, the High Court accepted that the potential effect, which in that case related to the potential extinction of the king shag species, was, although a low probability event, it was undoubtedly a significantly adverse effect, and that risk had not been assessed as being de minimis or a remote possibility. And Grey District Council submits that similar consideration apply here. In the context of landfill discharges to water or land, the courts have recognised, and I don't think there's any dispute about this, that there is a high level of certainty required, given the environmental effects and the clear significant adverse consequences of effects. The risk of contamination occurring here to the Grey water supply, though possibly a low probability event, is undoubtedly a significantly adverse effect. It is neither de minimis nor remote. It is a real risk that cannot be ruled out on the evidence, including the evidence of Ms. O'Rourke, who we'll hear from. Related to these concepts is the precautionary approach or principle. And I understand from what we've heard yesterday, there is no question that a precautionary approach is required in assessing these applications, given the potential for serious and irreversible damage to the Grey District water supply and scientific uncertainty. We heard a lot about conservatism, for example, in terms of the modelling from the applicants. And that idea of a precautionary approach is inherent in the assessment of potential effects. It's also relevant to the potential crafting of conditions, which we will return to. The precautionary approach may also require an activity to be prohibited where the evidence of effects on the environment are uncertain, unknown, or little understood, but potentially significantly adverse until further information is available, rather than taking an adapted management approach. And that is referenced to the case of Sustain Our Sound and New Zealand King's Sound. That question, the court said in that case, will depend on a number of factors, including the extent of the environmental risk, including the gravity of the consequences if the risk is realised, the importance of the activity, the degree of uncertainty, and the extent to which an adaptive management approach will sufficiently diminish the risk and the uncertainty. The overall question is whether an adaptive management approach, such as that is being proposed in terms of the trading conditions, will sufficiently diminish the risk and the uncertainty. The answer will depend on the extent of the risk and uncertainty remaining, and the gravity of the consequences if the risk is realized. For example, as was at issue in that case, a small remaining risk of annihilation of an endangered species may mean an adaptive management approach is unavailable. We will return to this point below when discussing the question of conditions, but add in that case, the Supreme Court noted that normally one would expect there to be sufficient baseline information before any adaptive management approach could be embarked on, as against prohibition, until any deficiency in baseline information is removed. In that case, the information deficit was able to be eliminated before the farms in question were stocked and feed levels increased. For reasons which we will return to later, the situation, we say, is different. Turning now to the evidence in relation to the Grey District Council water supply. Grey District Council's primary concern, although I stress it's not the only concern, but the primary one is with the applications in relation to the potential for significant adverse effects upon the drinking water. It is, as the experts agree in the joint witness statement, a particularly sensitive receptor, and its abstraction wells are closely proximate to the applicant site and the proposed discharge site. Samples from the proposed discharge are known to exceed health-based drinking water maximum acceptable values, MAVs, for manganese, arsenic, and chromium. Concentrations of other parameters without health-based MAVs were also measured in testing, and there are instances where concentrations exceeded ecological and drinking water aesthetic criteria. And I'm relying here on the statement of evidence of Mr. Stephens at paragraph 63.2, that's what noted. Grey District Council notes and agrees with the additional comment to Stephens in the joint witness statement regarding the variability of the results from, and that the highest parameters should be used for modelling. That is consistent with the conservative approach, precautionary principle that we have heard speak yesterday. And we also note that it's still not the case that all contaminants of concern have been tested for at this point. As explained in the evidence of Mr. Karen Smith from Grey District Council, Grey is the registered supplier under the Water Services Act for approximately 10,000 consumers and various community services, commercial areas and industry. The water supply is unquestionably regionally significant infrastructure, and it is identified as a lifeline utility for civil defence purposes. Grey District Council relies on high quality groundwater filtered through the gravels at the abstraction bores to provide its raw drinking water. Its current treatment processes, UV and chlorine, only treat biological contaminants, including protozoa and bacteria. There is also pH correction by the injection of dissolved lime. The treatment processes do not treat the contaminants that are of concern here from the proposed discharge, including heavy metals, PFAS, VTEX, PAH, benzopyrene, I probably pronounced that wrong, phenols and cyanide, those contaminants relating to coal tar and pitch, volatile organic compounds, and semi-volatile organic compounds. I can also add that Grey's screening processes don't sample for those either. The consequences of contamination to the drinking water supply are very significant and include the possibility of having to shut down the supply itself and a range of other very serious consequences that Mr. Parent-Smith will take us through in his evidence. The hydrogeological and environmental experts here are generally agreed, and I am relying on the joint witness statement, that a contaminant pathway, including seepage of contaminants from the discharge water into groundwater beneath the Pleistocene strata, and transporting through that strata to the extent of the terrace, where contaminants could then enter the roadside drain. The main concern for this flow path is transport into a stream that is closest to the grey water supply. It's referred to as No Name Creek 2. And infiltration then from this stream to the underlying gravel on the south side of Taylorville Road. This pathway is further explained in the evidence of Mr. O'Rourke from Tonkin and Taylor, and also by Mr. Stephens in his evidence. Tonkin and Taylor and PDP consider that there is still significant uncertainty regarding the potential effects of this flow path on the GDC bores, and there is not enough information on discharge water. Again, that's taken from the joint witness. A second potential flow path is the transport of contaminants downwards through the Pleistocene gravels directly into potential fractures within the Kayata Formation. This is the mudstone. And this is set out in the evidence of Ms. O'Rourke and again Mr. Stepp. Though less likely, if a connected fracture network exists, contaminants could travel through that fracture network to discharge again on the south side of Taylorville Road. While the applicant's experts appear somewhat dismissive of the potential for this flow path to exist, both Mr. O'Rourke and Mr. Stephens are aligned in the view that there has been insufficient investigation to rule this out. And again, that is taken from the joint witness statement. Ms. O'Rourke further details in her evidence, and she will explain later, the reasons why ground investigations do not sufficiently support the conclusion that this Kayata Formation is an aquiclude with no prospect of a flow, essentially. The hydrogeological and environmental experts agree now, it seems, on the suite of contaminants of concern that need to be tested in the proposed discharge, the groundwater and surface water, and that this should now occur to establish if they are present prior to the discharge occurring. Again, that's from the joint witness statement, and the contaminants in question are those that I have mentioned earlier: PFAS, VOCs, SVOCs, cyanide, TPH. These contaminants are in addition to the analytes that are required to be tested under pre-existing consent conditions. This is really crucial. Contaminant testing is critical to assessing the environment. Testing of the proposed discharge is needed to inform a revision of the contaminant, bait, and transport modelling. This will show what contaminants are in the discharge water, and it will inform interpretation in relation to dilution effects and other attenuation mechanisms, travel times, what concentrations are predicted to be present at the point of receptors, such as GDC's boards, and potential trigger levels for monitoring purposes. PFAS, for example, can travel long distances without breaking down and have low limits for MABs, and they are a key emission from the sampling presented by the applicant so far. Testing of the receiving surface water and the groundwater is also required to provide a baseline of existing conditions prior to the proposed discharge, both on-site and off-site in the vicinity of the GDC bores, given the generally agreed potential transport path. This will enable existing contamination to be identified, which is relevant to the assessment of cumulative effects, as well as the effects of mobilizing existing contaminants by the discharge identified by Dr. Durrett. It's also critical for monitoring and identifying changes to the surface water and groundwater conditions caused by the discharge. Ms. O'Rourke's evidence sets out material gaps in the hydrogeological information presented by the applicant. And these are not just academic gaps, they are material, and they go to the heart of the assessment of environmental effects. The extent of these information gaps mean there is considerable uncertainty regarding the hydrogeological understanding of this site and the contaminants in question, and that has prevented an adequate assessment of environmental effects. Ms. O'Rourke will take us through that this morning, but I'll mention some. There is insufficient information, for example, about groundwater flow directions, and this is under existing conditions at the applicant's site towards the GDC board, not accounting for the question of discharge and mounding. For example, based on the number and location of monitoring wells, there is uncertainty about groundwater flows at the site, particularly to the south between what are termed wells MB3 and MB4 and off-site towards GDC's borders. Ms. O'Rourke will explain this better than I will, but essentially what I understand is the groundwater elevation contours presented by the applicant are limited to one round of monitoring in its updated hydrological assessment, and additional monitoring wells south of the existing wells at the site are needed to understand the groundwater flow directions below the existing wells covering this crucial area nearer to Taylorville Road and to the GDC borders. There is additionally no information about the potential for preferential flow paths within the Pleistocene gravels. Preferential flow paths, which are areas or zones of higher hydraulic conductivity, can result in groundwater flow directions that are different to what might otherwise be expected, and they may affect different discharge points and faster travel times for contaminants, and all of this can alter the assessment. Leachate elevations and the influence of pumping of leachate from the southwest corner of cell A, which is an unlined cell with its base in mudstone, is not discussed. And again, this could influence groundwater. There are also concerns about the interpretation of data relating to the hydraulic conductivity of this Pleistocene gravel and Kayata formation. For example, slug testing in MB19D is presented in the updated HA as an assessment of the hydraulic connectivity in the gravel. However, the driller's log, when scrutinized, indicates that this well is actually mostly screened in mudstone. And the result is presented as a relatively low measure of hydraulic conductivity for the gravel, but it would be a high value for mudstone. The presentation could therefore be underestimating the conductivity of the gravel, or it may alternatively illustrate high connectivity in the mudstone. Another issue, the screens for monitoring wells BH013, BH014, BH019 have been constructed in such a way that they are across the contact of the Pleistocene gravel and the Kayata formation. And this means that the results in terms of groundwater levels, groundwater quality, and hydraulic conductivity are averaged, they're blended across the screened formation, and they may not present accurate information for each individual formation. There are also various gaps in the information presented relating to the construction of the monitoring wells, for example, an absence of bore logs, an absence of photographs of soil or rock core, an absence of information about well development information, an absence of information about quality assurance and control measures, field sheets in relation to the water sample that could affect the interpretation of the data and the reliability and robustness of the assessment. We've heard a lot about the hand-touch model in relation to groundwater mounding effects from the proposed discharge. This has evolved considerably since the initial presentation in the preliminary hydrological assessment. The most conservative scenario that is now presented in the updated assessment is premised on a discharge of 300 meters cubed daily over 6 months. And that produced a significant predicated mounding effects of 7 meters at the edge of the proposed soakage pit and 0.95 meters, 250 meters from the centre. This will induce groundwater flows to the south and radial flows in all directions. There has been no overlay of those mounding effects on the groundwater contour plans for existing conditions to assist with this flow interpretation. Second scenario, based on discharge over 5 days per week, produced more conservative mounding results of 3.77 meters at the edge of the pit and 0.02 meters, 250 meters from the centre. But this will still induce some changes in flow direction, and there remains uncertainty about the extent of mounding under this model, because the model assumes a continuous discharge over 24 hours, whereas the actual operational scenario indicated is that the discharge will only take place during daylight hours when personnel are on site. The model additionally does not explain if the mound would fully dissipate over the weekend or not before the next week of discharge commences. On this model, therefore, mounding could still induce flow to the south to discharge to Taylorville. Turning now to the question of pre-existing contamination of groundwater and surface water. There are questions about existing contamination of waters that have not yet been adequately established as part of the baseline condition. Dr. Durant identifies in the Section 42A report correctly in GDC submission that Condition 11 prohibited contamination of land or water outside of the site, but such contamination likely has occurred and is likely still to be occurring. Leachate from cell A is likely to have already been discharged into land and groundwater within the site. That is the unlined cell. The site's other lined cells may or may not also be. In reality, contaminants are likely to be present in groundwater within the site as a result of the operation of the landfill. And contamination of this sort was not accounted for in the decision-making under the original consent, and if it were, it would have been recognised that groundwater flows would intercept and transport the leachate out of this site. The hydrological evidence, as it is understood by Dr. Durant, is that the proposed discharge, because it will contribute more water to the groundwater, it could flow in such a manner that it could intercept these contaminants from the base of cells and mobilise them to eventually daylight in one of the sites surrounding water bodies. The question of existing contamination is covered in the applicant's own evidence. Mr. Griffiths, the applicant's land and geology expert, acknowledges quite properly in his statement of evidence, as cell A is online, it is reasonable to infer that not all leachate generated at this location is collected by the sump, and therefore some leachate is infiltrating directly to ground. He also identifies that a comparison of data obtained from upgradient and downgradient locations indicates that some impact to groundwater is occurring across the site. Key chemical indicators include sulfate, chloride, ammoniacal nitrogen, and heavy metals. This is likely, he says, attributable to fugitive leachate from the active waste cells. And GDC reminds us here that not all relevant contaminants of concern have yet been tested in those samples referred to. The Grey District Council Drinking Water Safety Plan is attached to Mr. Perrin's statement of evidence, and that records the question of pre-existing contamination too. It refers to an investigation by the Environmental Protection Authority in 2023, which confirmed that contaminated water was being discharged from the applicant's site. It's that investigation confirmed, as it is recorded in the Drinking Water Safety Plan, leachate from lined cells B and C was drained both to unlined cell A and to an unlined sediment pond. And from there, the leachate circulated to a holding pond and back to unlined cell A, where it drained again to the unlined sediment pond. So there was this travel and circularity between the various cells, from lined cells B and C, but to unlined cells A and an unlined sediment pond, giving that opportunity for leachate to be discharged. Data from a leachate sample in August 2022 showed parameters for arsenic, copper, lead, and nickel were 200 to 1,400 times greater than the MAB zone. The Drinking Water Safety Plan also reports that no detail is available on the construction of the liners in cells B and C, nor on how waste material was to be placed within the lined cells. Materials with sharp edges or that land with force may compromise those liners and provide an additional pathway for leachate to escape from a lined cell into the surrounding gravels. And we heard from the applicant's evidence yesterday some discussion about how wastes are received on site, moved by an excavator, essentially, in terms of those cells. And this does raise questions about the integrity of those liners. Cell A, which is operational, is still unlined and it receives a very broad range of demolition waste, as well as whole and shredded tires. And this is detailed in Mr. Griffith's statement of evidence at 28A. I have footnoted, and I won't go through it all, but it is a very, very long and varied list of demolition waste. Cell B, closed and capped, and cell C, operational, were consented to receive demolition waste containing asbestos, coal tar and pitch, and other hazardous materials approved by the consent authority. Again, that's referred to in Mr. Griffith's statement. Other materials received include contaminated soils, that's referred to in Ms. Taylor's evidence, significant amounts of green waste that generated biological activity and odour, that's referred to in the Section 42 report, and an inappropriate deposition of a large volume of organic matter, so the diseased tomato plants, in cell C, and that is referred to in Mr. Gray's evidence. Mr. Gray's evidence goes on to say in relation to that organic matter, its effects may possibly have passed or be temporarily reduced due to seasonal changes in groundwater and rainfall interaction, cell C, but future interactions between groundwater and the fill within the land cells, causing further stream impacts, cannot be ruled out. We also know that other landfill activities were previously carried out prior to the applicant's ownership, presumably at other locations on the site. The applicant has given us some information of their knowledge of that, relating to disposal of road materials, demolition materials, uncontaminated soils, sand and gravel, which were halted. But as the applicant's evidence acknowledges, again, Ms. Taylor, the impacts of that earlier activity are the impacts of this uncontrolled discharge to groundwater that has likely already occurred and that may still be occurring is not well understood. And again, that's due to the inadequate testing by the applicant and an insufficient understanding of the hydrogeology. And it is not something that seems to have received an awful lot of attention in the applicant's evidence, including what was discussed yesterday, and that is despite the fact that this is specifically referenced in the Grey District Council Drinking Water Safety Plan. There is the potential for those contaminations to move. Preferential flow paths applies to seam gravel, for example, or the potential for fracture flow paths within the Kayata Mudstone present potential ways for this contaminant to travel, including towards the groundwater on GDCs. Further investigations and sampling are required to rule in and depending on the result to understand the effects of such contamination in conjunction with the proposed discharge. There is also risk that the existing contamination at the site could be mobilized also by the proposed discharge, and that also needs to be taken into account in the modelling, both in terms of the effects upon the GDC water supply, but also in relation to ecological effects. As Ms. O'Rourke explains in her statement, and as she will explain further, the baseline condition of groundwater, if it shows pre-existing contamination due to other activities at the site, that means that the assessment of effects would need to consider potential changes to the fate and transport of pre-existing as a result of discharge. At this point, unless you have any questions for me on any of that, I might hand over to Mr. Sylvester.
I do have one question, if I can take you
Yes.
back. And I will have some questions for Mr. Smith about this as well, but I'm just wondering if you can help me with the legal aspects of it. And this relates to an assessment of effects and what the appropriate thresholds are for evaluation of those effects as they relate to a drinking water supply. So I think I well understand how, in the normal sense, under the RMA, whether effects are minor, less than minor, or not, or whether you get a de minimis situation. What I'm trying to understand in the context of the drinking water supply, which has another set of criteria applying to it, and a lot of the evaluation, as you rightly note, has been undertaken against maximum acceptable values, MAVs. Now that's a standard approach, but what you might be able to assist me with here in terms of the legal position is, If you think of the context of the framework for managing a drinking water supply and what the Water Services Act requires, can you assist me with whether those thresholds are appropriate? When you think of likelihood and consequence for a drinking water supply, so what are the appropriate threshold values that the effects should be assessed from a legal perspective? And that considering all those factors.
I would say it is those MOVs, those maximum acceptable values in terms of the drinking water supply. Now, there are questions about what trigger levels potentially could be identified before a contaminant reaches those bores, but certainly there cannot be any risk of those MAVs being exceeded at the point of the bore. And the assessment of environmental effects has that difficult, I suppose that difficult question of having to understand what are the values, what are the concentrations of those contaminants, what are the effects of these two potential sources, the existing contamination that hasn't really been tested for yet, the proposed discharge, and how can that be managed in terms of avoiding adverse effects that those MAVs never reach the point. And there will be different levels of values that will apply to ecology. Mr. Sylvester will talk about too.
Yes, yeah, I wanted just to stay with the human health side at the moment. So just to confirm what you were saying then, so from GDC's perspective, the MAV would be, and if we think of PFAS, so it will vary, all of those criteria will vary. But in terms of the strict liability and the precautionary principle that would apply to drinking water specifically, and the obligation to deliver safe drinking water, so those are obligations which are now absolute in the Water Services Act, correct? So are you confirming then that GDC would be, in that context, would be comfortable to accept the MAV at the intake would be the appropriate value?
Yeah, so we do have quite detailed submissions on this.
Oh, okay.
So it is.
You're coming to that. That's
I can
good.
address it now, because this is set up, starts from paragraph 54 of our written submissions, and it really is the crux.
Yeah, if you're coming to it, if you kind of sort of
Yeah.
bring those two aspects together at that point
Yeah.
about what the legal position is versus what the operational perspective is under the Act, that would be fantastic. Yeah. Thank you.
Why don't I actually read that direction now? And
Look, if you're coming to it, that's
it is the first one.
Yeah, great.
So I'll give you an overview of the legal aspects. I know that we have given you quite comprehensive submissions here. And I'm just noting the time. I will kind of focus on the high level parts of this and then leave you with some of the detail later on.
Thank you.
But in terms of the aspect of the submissions that I will make, I will first focus on these frameworks that are relevant for your decision in relation to setting conditions. So that includes the thresholds for the drinking water. And I've broken this up into two issues. So first will be these legal tests in relation to drinking water supply. That's the first section. And then the second section I'll address is that in relation to ecology as in the statement. And then lastly, I'll deal with the issue of conditions separately and what that operational side looks like. So in terms of what is set out from paragraph 40 to 43 is housekeeping. We note that there is quite a lot of different instruments that you will need to have in mind in terms of making this decision. In relation to drinking water, these have been largely canvassed by the other submitters so far, and then Dr. Duran's section 42A report. But I'd note that paragraph 42, in addition to that, those considerations, the last three in particular are really relevant. So 42D is the regulation that sets the MAV standards that we're discussing. 42E and F are also quite important instruments. These are a form of secondary legislation created under the Water Services Act. The drinking water quality assurance rules set standards for local councils to do their monitoring and their compliance. So these rules have quite a lot of detail about what they need to do in different circumstances. And Mr. Perrin's Curtis's evidence will address some of these aspects as well. It's kind of in the background of the drinking water safety plan. And the last one, 42F, has not had much attention yet in these in this hearing and evidence so far, but these are the aesthetic values for drinking water. So previously, these were included in the drinking water standard under the Health Act, which is, so when the NES was drafted, that's the instrument that it was referring to. Under the Water Services Act, these two instruments have now been split, but we would submit that they should be taken together and that the intent of the NES to refer to this is still in effect. In terms of the first part, going back to submissions on, that is, Melody Senior has addressed, there is a significant amount of uncertainty and information issues within these consents. So starting at paragraph 44 of our written submissions, we agree with Dr. Durand in his section 44A report that so far the information is incomplete. It is uncertain. It relies on quite heavily conceptual information and incomplete and non-representative data. This information creates uncertainty for how section 104 can be applied. We submit that section 104, subsection 6, is engaged in this circumstance and that there is just not enough adequate information, too much uncertainty about what needs to be done for a consent to be granted here. Turning to the framework for drinking water, in relation to the effects on the drinking water supply, and this is from paragraph 46, the essential question for the Commissioners so far in the evidence is really whether there is a possible contamination pathway from the discharge point to the drinking water supply. As has already been set out today, and in some of the evidence yesterday, and will also be brought up in evidence by Ms. O'Rourke, there are quite a few different pathways that could exist here. We're not dealing with just the mudstone as the pathway, but there's the oversurface water. The amount of contaminants into the environment have lots of different ways that they may affect the water supply. And if any of those are viable, it is GDC's submission that a consent should not and cannot be granted. We note at paragraph 47 the requirements of...
Sorry, just
No, I did, but yours might be the same
Okay.
question. Just on that point, if we might check on that.
Well, what I was just going to ask was whether when you say that pathway could exist, a consent cannot be granted. So is that basically prohibited?
Yeah, we submit that it is.
If there is any possible pathway.
Then, yeah, if it's going to be one that is even a low risk, that will tip the threshold. If it is totally implausible, negligible, like the moon is going to crash into the planet, it's not saying it's likely to happen, then that kind of sort of absurd risk almost can be discounted. But when we're dealing with quite low risk, or even the risk that the cumulative effects are going to build up over time, that's going to push it over. In the context of drinking water, where there is quite extensive different considerations at play, that even that low risk needs to be treated quite seriously. And we would submit in support of that as well, is that at this stage, the information for you is too uncertain to actually support sufficient conclusions about the level of risk. We only have a conceptual understanding of this hydrogeological environment, and further baseline work has been suggested. But one of the aspects that may come out in further investigation is that this risk may increase. It may become clearer that there are even more risks that haven't been considered. So our primary submission is that you do not actually have enough information at this stage to make a decision that sufficiently covers it. And the fact there may be a potential pathway is sufficient to put a halt on this and decline the consents in your discretion.
So my question was similar, but probably just exploring that a little more closely. All risk assessment relates to sort of pathways receptor. So I think we've canvassed a lot of those things, and to establish a risk, you need to have those three. And so I'm not discounting your point about the pathway and the uncertainty that relates to that, but to conclude that, and that has to be seen in the context of a potential source. So that the extension must be that it has to be seen in that light, because there are pathways across the country for water supplies.
Yes.
And the risk is established by that full combination. So all I'm saying is this seems to need to have a caveat on it.
Yes, and I note here as well that I might be using pathway in more of a general sense, that the technical sense of just that linkage. If there is no source of contaminants, then
So I think it is an important point though, because that the pathway discussion and the evaluation or not, and the uncertainties around that relate specifically to whether there is a route, a viable route from A to B, and it doesn't relate necessarily to what the nature of the source or the receptor, but the receptor is clear. I think there's no doubt about that. The pathway has got uncertainty related to it, and then there's the context of the source, what could be contributed to that pathway.
Yes.
So I think it's just important that we record that.
Yes.
In this discussion here.
I agree, and I would note that Mr. Wood can help you with the technical detail.
Yeah, thank you.
I will canvass paragraph 47 that sets out the requirements of section 104G. What we would note here is the drinking water safety plan was cited by GDC in our original submissions back in July, and it is at footnote 8 if anyone needs to find it. But what we just want to stress is that there seems to be some uncertainty about whether Gray had this information at all, and this information has been relied on in Gray's forming their position, and it has been available at all times to the other parties, and leave that there.
How was it available?
Well, in terms of available, someone needed to ask.
It wasn't just while we're on that point, and it was a question again I had for experience. There was an information request of GDC, and I didn't go back and explore exactly what the nature of the request was, and there was information provided back which didn't include the drinking water safety plan, which had been incredibly helpful as it now transpired. But neither were, and they're not publicly available. But then again, the applicant should have known that such a plan had to exist because it's a requirement and it would be rigorous. So just in that light.
Yes, I know that Mr. Parents would probably be the best place to answer some of the technical aspect of that. I have seen the information that was provided. What I understand was the only request from the applicant. There may have been more that I'm not aware of. And that related to water testing within the water supply. It wasn't a request for information about the drinking water safety plan or some of these other details. Just a narrow aspect.
But in that response, there was technical information about testing of the bores, and so some that would have been helpful to the applicant to establish what the real issues and the vulnerabilities of the supply might have been. But the real key, the crux of the quality information is there in the drinking water safety plan already, which would have been incredibly helpful to the applicant to understand that essentially the vulnerability of that supply and how that needed to be addressed in the application. Thank you.
Wait for it. Returning to our submissions here, and this goes to your questions about some of the risk at paragraph 50. The specific consideration of the effects on source water and the assessment of risks identified in the source water risk management plan, which is one of the appendixes to the drinking water safety plan, We submit that this requires the commissioners to place significant weight on this cautious approach. This is to ensure that managing drinking water is protected. And we note that the section 104G has a close relationship with the Water Services Act. These should be read in this context, and the purposes of the Water Services Act should form the caution that is taken through section 104G. And I will come to that in submissions. It is our submission at paragraph 51. The main purpose of the Water Services Act is to ensure that drinking water suppliers provide safe water to consumers. This legislation, as I understand you're both familiar, is a response to the systemic failure in the Hawke's Bay Regional Council in granting discharge activities that were limited in their assessment of the risk to the council's drinking water supply. That is what I'm referring to as the Havelock North Drinking Water Inquiry. Alongside the principles that Dr. Durant has taken from that inquiry, we would submit that the purpose in the Water Services Act gives significant weighting to these instruments, and a significant weight should be placed on the drinking water source plan and its assessment to the drinking water supply. Here, the risk of major contamination would have very significant adverse effects. This is set out in Mr. Perrin's evidence, and I won't repeat this now as it's been discussed already with you sirs. But I turn to paragraph 54. We're talking about the National Environment Standard here. It's our submission that Regulation 7 prevents granting a discharge permit for an activity such as this. We submit that the elements which my learned friend for the applicant has set out in their submissions, the key one being here first, that the discharge will occur upstream of an abstraction point where the drinking water concerned meets the health equality criteria, and if this activity is likely to introduce or increase the concentration of any determinants or aesthetic determinants in the drinking water, then a consent should be declined. And that's if it exceeds.
Can I just stop you there again, Sylvester? And it really goes back to 52 actually. And I was just going to see if you were going to come to address this point, because you did mention specifically a source water risk management plan. One aspect of that, so all of that discussion I understand to be absolutely right and having presented that. The one thing that you admitted there was the consultation that's required, and it's not required under a drinking water safety plan, but it is under a source water risk management plan. And that drinking water safety plan addresses the risk that is posed by the TRPL facility and goes into some detail in evaluating that. Now, one obligation under source water risk management planning is consultation. And are you aware of that? That there's a requirement to consult those parties within the catchment once the risk profile is established within the catchment of concern. And it came up yesterday, and I don't know if you picked up that point, but the applicant said, well, we weren't aware. We hadn't been approached about planning that Grey District Council would have had to do, and the consultation that would have had to have gone with that. And if they had known that, then they would have been aware of, or more aware of the risk that potentially could have been posed by that, which was already identified and evaluated within the drinking water safety plan. Do you see what
I see where you're getting at. I did have a look at the legislation yesterday after you raised that point. And my understanding is the consultation requirements aren't particularly well spelled out in the definition of the source water risk management plan, but it is something that would likely be appropriate under the Local Government Act. I don't have the detail to hand about whether that was done or not.
Yeah, it's commensurate with the level of risk.
Yes.
Actually, so that it can be very detailed.
Yes.
If you've got, a city sitting above your water supply, then obviously a very high obligation. So yeah, there is some debate potentially about that, about what evaluation that should need to be. But do you think in the circumstances would be a both consultation?
Well, I see the issue. I just note that I probably need more information from the client around that. And I would just know that it's that consultation aspect in an ideal world, TRPL would have been aware of this instrument at an earlier stage, whether that was from a legal or proactive consultation. Unfortunately, that's what seems to have occurred.
It's just exploring these opportunities under these various frameworks to share information and gain a better picture of what the reality of the situation is.
And it would likely have brought a clearer picture of a proactive approach was taken.
And just on the point, so just so I'm clear about what you were saying, in response to the question is, do you consider that no consultation at all would be acceptable?
I'm not taking a position on that aspect, because I think there are other factors that also have to be considered for the council in that work program, and I don't have the information at this stage. I need to take instructions.
So got to start the factual matters from a legal perspective. Do you consider that no consultation at all would be acceptable or appropriate?
This is probably a circumstance where consultation makes sense, but it also requires a bit back and forth. We're not in this ideal world where we have a clear picture of some of those earlier stages. But I would take us back to the test that we do have. So turning to paragraph 54 of my submissions, in terms of the tests that need to be met, there does need to be a assessment of what is upstream of this abstraction point. It is GDC's submission based on the hydrologist that is engaged. We submit that Regulation 7 is a prohibition on allowing a discharge permit for an activity that will occur upstream of an abstraction point if that activity is likely to introduce or increase the concentration of any determinants. In the expert conferencing on hydrogeology, the experts have agreed that there are some potential contamination pathways that would increase the level of that increase is still a bit unclear. However, we'd submit that there is still a live risk. The NES does not direct a measure of likelihood, and however consistent with the approach to risk under the RMA and the purpose of that should say NES sources of human drinking water, the existence of a risk in these circumstances justifies declining the consent. We've had a bit of a discussion about the Water Services Act, and so paragraph 57 is reinforcing that again, that this is a legislation that requires extra care and that needs to be taken into account. I note at paragraph 58 as well that at this stage, we understand that no assessment of the aesthetic values or the effects on aesthetic values has been undertaken. NGO has, in their assessment, excluded consideration of, in particular, sulfides and hardness that had high readings in their treated discharge. They have excluded these, they say, on the basis that they pose a lower risk to human health. However, they are also aesthetic determinants that require expert assessment against the guidance prepared by Taylorville Ottawa. And this aspect of Regulation 7 just has not been assessed in the applications for you. It's our submission that the applicant can't choose the contaminants or which guidelines will be exceeded. They all need to be considered. Turning to Regulation 12 of the ENS, we note again this has not been considered by the applicant or Dr. Durand. This regulation is relevant in our submission to the current circumstances, and it requires a consenting authority to consider whether the activity may, and A and B are taken from the Act, that whether the activity may itself lead to an event occurring, for example, the spillage of chemicals that may have significant adverse effect on the quality of water at any abstraction point, or as a consequence of an event, for example, an unusually heavy rainfall, have a significant adverse effect on the quality of the water at any abstraction point. These are mandatory considerations for the commissioners to consider. We observe the applicant has not provided an analysis on these issues. In particular, the applicant has accumulated significant volumes of contaminated stormwater on site. The proposed activity, and we note that it is still very conceptual designs, It involves piping and moving this accumulated contaminated water, as well as collecting it in another pond. There has been insufficient analysis of the risk of these ancillary activities that present a risk of discharge if something goes wrong, and that discharge may enter surface water or land outside of their intended soakage pit. We submit that a conceptual design is insufficient for dealing with considerations in Regulation 12. The further detail provided in the consent conditions last week does not address the other potential issues that could arise. A greater degree of evaluation is required than has been prepared for the application documents, and that is necessary for the protection of human health and the drinking water supply. We note at 62 that if the commissioners are minded to grant the consent, regardless of the insufficient information, the requirements of Regulation 12 and 3 must apply. These mandatory conditions require the applicant to be notifying Grey District Council as the registered drinking water supply operators of any event of that has the above characteristics. We note that the burden in all this on GDC of even a minor contamination of the drinking water supply, and we note that we heard from Mr. Griffiths and Mr. Berry yesterday about their assessment that there might be these minor increases. That is going to have a disproportionate cost to Grey District Council than it would to submission. The monitoring, compliance, and potential treatment cost increases for Grey District Council, if this discharge is granted, will extend beyond the time frame of this discharge. The costs of this are unknown at this stage. They're hard to quantify because at this stage everything is still conceptual. But they will be significant, and they may significantly exceed this figure of 850,000 mentioned by the applicant for trucking contaminated water to Christchurch. This consent should not be granted in this context, where there is such significant risk. We note then that the National Policy Statement for Fresh Water provides further direction around the assessment of the drinking water supply and some of these connected aspects. We ultimately agree with Dr. Duran's assessment in section 42A that the applicant has provided information that is not based on the best information. The information has not been adequately improved since the applicant's evidence. The joint witness statement identified significant areas of uncertainty and incomplete information that remain based on Ms. O'Rourke and Mr. Steffen's evidence. These are still very live uncertainties. This issue is then repeated by the two ecologists' joint witness statement that highlight that there is uncertain and incomplete information relating to what has potentially affected wetlands by this discharge. In response to 622 of the planning joint witness statement, the information collected during the exercise of the consent would not allow the effects to be adequately avoided, remedied, or mitigated. If, as contemplated in this joint witness statement, the information collected is about what the discharge will actually contain, this approach would create an unreasonable risk to the drinking water supply. There is insufficient information to justify GDC will be in a position to be able to process an increase in these contaminants. If based on the approach outlined in the hydrogeology joint witness statement, then further testing and evaluation of the site is not consenting with certainty and oversight that the conditions will allow the adverse effects to be avoided, remedied, or mitigated. Rather, it would be limiting the control to be determined out later. Grey District Council submits that the proposed discharge is not consistent with the National Policy Statement for Fresh Water. Fundamentally, the applicant has not assessed the proposed activity against the policies fully or aligned its activity with the requirements. The directive policies contained in the NPCF need to be complied with. The non-compliance is not able to be addressed in conditions because the full extent of potential adverse effects is still not fully understood. The applicant has not discharged its burden of assessing the activity against all the criteria. Further information is required. In terms of the West Coast Regional Policy Statement, I will cover this fairly lightly as this has already received attention. We would just note that it is quite clear we're dealing with an undisputed regionally significant infrastructure. It is GDC's submission that the TRPL landfill does not meet the threshold for being a regionally significant infrastructure under the regional policy statement. What is referred to in the regional policy statement is public or community. The overall aspect, and if you read the policies altogether, is focused on infrastructure that is being maintained by the councils or regional council or central government. It's not a private landfill for profit serving businesses. It is more focused on community waste or community facilities of that nature.
And in your 17, when you talk about the disproportionate weight, that's just that you're saying we shouldn't be trying to balance, but
Yes,
because of the regional significance.
that's right. Yeah, it's our submission that this is not a conflict between two regionally significant infrastructure. This is an issue of how we protect the drinking water supply. Turning to the West Coast Regional Land and Water Plan, we ultimately agree with Dr. Duran's assessment. In particular, we stress that policy 3.31 requires that priority must be on this avoiding of adverse effects. There was discussion yesterday about what that meant, and we agree with the position that this is giving preference and a thorough assessment first, how it will be avoided. In addition to what is set out at paragraph 195 of the section 42A report, we note further that the applicant has not adequately assessed how it will avoid the contamination pathways or sources of contamination. That conceptual models, and this is all agreed in the joint witness statement, that this has not been fully assessed yet. There is a substantial conceptual difficulties with the hydrogeological environment that prevent a thorough and efficient assessment of avoiding the adverse effects. The proposed reliance on future discharge management plans is insufficient to determine whether the activity will avoid the adverse effects. The applicant is relying on monitoring to mitigate potential effects there. Mr. Griffiths was talking about that yesterday. This is about monitoring to mitigate. It's not about avoiding. It's not being designed with avoiding in mind. And that is our assumption that needs to be priority. The expert hydrologists appear to agree that these effects are potentially avoidable. So we acknowledge that there may be a way to make this discharge work that doesn't have these effects in the environment. But at this stage, that information is insufficient. The consideration of how to avoid the adverse effects has not been given sufficient weight and attention by the applicant. The applicant has been on notice from the requests for further information in 2024 from Carl Stephens that further detailed investigations were necessary to determine the baseline environment. They need to confirm the design of the soakage pits and collect the information to form the assessment of effects. The conceptual nature of the proposed activity and the uncertainty of foundational understanding limits the ability for the discharge to be designed to avoid adverse effects. I note also policy 3.311D and F of the NPSFBM are potentially also engaged on the joint witness statement. The ecologist, as Ms. Drummond has acknowledged, there is a wetland in the area and it is likely to be affected or potentially affected by the discharge of contaminants. And it is part of the relied on pathway to avoid some effects. We note here that the applicant has not assessed how these adverse effects can be avoided on the wetland, and a further assessment really is needed. And I'll discuss that further in apology. I might truncate this as I realize we're getting close to needing a break. We set out from 75 through to 18 further considerations around the Water Services Act that we've discussed in question 3D. Turning to ecology, our overall crux here is that from the evidence of Ms. Drummond yesterday and the joint witness statement with ecology, further work needs to be done to assess the ecological effects, in particular the presence of this significant wetland that is noted in the joint witness statement raises concern that there is an aspect of the National Policy Statement for Freshwater and National Policy Statement for Indigenous biodiversity that has not been considered at this stage, and that further work needs to be done to investigate this and to carry out the actual assessments on the plan and see whether any adverse effects can be avoided. I'll turn now to conditions. So I am skipping quite far ahead. So if you have any questions about biodiversity.
No, carry on. We'll come back up to more temporary.
So to overview of the Grey District Council's position on conditions is that the applicant's information deficits cannot really be cured through the use of conditions. We note the Environment Court and Remediation New Zealand Limited and Taranaki Regional Council has said management plan consenting is not a system in which parameters and objectives are left to be set by a management plan. They must be set in the conditions, and there must be evidence that the parameters and objectives are attainable. The management plans should not delegate key decisions / actions to safeguard the environment to a later date. Although a management plan can provide information on how parameters or limits can and will be met, it is inappropriate for the limits themselves to be left to the management plan. Those must be set in the consent itself, and there was acceptance of that. In Sustain Our Sound mentioned above, there is more discussion about whether an adaptive management approach will sufficiently diminish the risk and uncertainty. The answer will depend on the extent of risk and uncertainty remaining and the gravity of the consequences if the risk is realised. In addition, the court noted that it would normally expect baseline information to be sufficient before embarking on an adaptive management approach. We note Environment Court's practice note from 2023 that was cited by Ms. Bessier yesterday. We agree with the parts that she set out, which is L, A, B, C, and D, and we add also A, which is that conditions should make sense and be coherent, consistent, and complete. There should be clarity, certainty, and enforceability for all conditions. In this case, an adaptive management approach is not appropriate because first, conditions have not yet been agreed to, and there is doubt about whether this is achievable. The experts have not yet been able to agree on what their conditions should cover. Second, the parameters and objectives for a management approach are dependent on further investigation. The expected program of further work requires an investigation of the baseline to test the risk, to then set the parameters and objectives, which then will inform the ecologists, which will then need to go to the planners. There's a lot of steps that needs to happen for these conditions to be either workable or to draft. And we submit that that is not going to meet the requirements of the tests. Next, we submit that points of disagreement still remain between the experts, including in relation to investigating fracture flow and the formation and the ability of these gravels to accept the volume of discharge. The further investigations contemplated by the conditions could take up to 3 months and may result in a need for further investigation after that. We submit that crafting of clear and workable conditions is likely to be difficult and proved to be the case so far. The information gathering and monitoring conditions are going to require extensive auditing and review by West Coast Regional Council, and we submit that it's just not justifiable. The implementation of any conditions, if they are to be formed in the first place, will demand a level of operational vigilance by the applicant that GDC submits has unfortunately not been demonstrated in its activities to date and cannot be assumed. The design of the proposed soakage pit is still at a conceptual stage, with key inputs including the filtration capacity still to be determined in a detailed design, and with questions as to its viability to achieve the discharge the applicant wants. The very location of this pit has not yet been confirmed. Well, we note yesterday's comments that it's 90% confirmed. There remains considerable scope for disagreement with the experts. The modelling approach contemplated by the conditions cannot account for the presence of PFAs. The applicant's expert discussed a potential need to treat the leachate to deal with PFAs and otherwise referred to existing treatment methods to reduce the level of concentrations before the discharge in a generalised way. Reliance on treatment methods to reduce contamination concentrations in the leachate, including such methods that might be employed to attempt to treat PFH is verging into the territory of a new activity that is beyond the scope of conditions for this type of consent. It's getting more and more complicated. The further investigations contemplated are critical to the understanding of the proposed instruction. This is a matter for the commissioners that should not be deferred to an action plan. There is possibility that consent may not be exercised in results. Baseline information is absent, and this is not a simple matter to rectify. Significant further work is required, not just in terms of hydrogeology, but also, apologies for the typo, but also in relation to ecology. There are very significant omissions in the ecological assessment, primarily relating to these wetlands that have been raised by Australia's evidence. And these eels, which are an at-risk species and deserve protection under the NPSFM, NPSIBs. There needs to be much more further assessment to determine what these effects are going to be. The effects of this proposal turn majorly on findings of future investigations, which prevents a fair and reasonable process for submitters to participate or for the council to consider the activity fully. We heard Ms. Bessier's points on that yesterday. We have similar concerns. The extent of work that needs to be completed before the close of hearing is just too high. The situation does not enable confidence that workable conditions can be achieved. Fundamentally, the applicant should have addressed these information deficits in the application process and has had many opportunities to do so. GDC submits that the applicant has tried to address the relevant matters. There is just too much uncertainty to form consents. The level of input required and the need for evaluation of the various inputs effectively replicates the process for an application for a resource consent. Should the commissioners be minded to entertain conditions, GDC's minimum requirements are set out in Mr. Perrin-Smith's evidence. It is not possible at this point to quantify a bond and or a financial contribution amount, given the extent of the uncertainty. GDC does wish to comment on any draft positions, and we appreciate that there will be discussion later about what that next step will look like, and GDC would like to have an active role in that as well. In terms of alternatives, GDC's position on alternatives is set out in Mr. Perrin-Smith's evidence. Yesterday, we heard about the construction and use of wetland. We heard about these potential other designs and these other aspects that are coming up, including ways that PFAs could potentially be treated. So it sounds as if there is some alternatives, but the applicant appears to still be identifying these, which have not yet been adequately assessed. GDC does prefer the safest option of tracking the leachate to an offsite facility in Christchurch or constructing another holding pond until there is a way to manage the leachate in a safe way. Those are the legal submissions for Grey District Council. We know now would probably be an appropriate time for a break. And then we've got Mr. Perrin-Smith at the table.
Come back just after if you want.
Look, can I just touch one thing, and I think we can deal with this really quickly and then go to a break. At 105, you referred directly to the quantity or the nature in terms of a bond. I mean, it is the position that a bond is an appropriate remedy or in itself in principle or not?
We submit that if something is going to happen, we think a bond would be appropriate to secure the avoiding. Whether it's a bond or a financial contribution, we agree with Mr. Durant that further work needs to be done that side. In particular, if something goes wrong, it can be catastrophic for the Grey District Council.
Absolutely.
And something needs to be in place to protect them in that circumstance. And it's up to
Yeah, that's just what I was seeking to clarify. Thank you.
All right, we'll take a break for 10 minutes. Well, thanks. one stage. All right, welcome back. We'll move on to your first witness.
Thank you.
So you prepared a memorandum, a summary rather, so it's like step us through that.
Really, thank you. Thank you for the opportunity to address the hearing today on behalf of the Grey District Council. My name is Curtis Perrin-Smith, and I'm the Group Manager of Operation Grey District Council. Worked at the council for over 20 years and have held responsibilities, including the management of the council's drinking water supplies. For clarification, where I use the term council in the summary today, it is with reference to the Grey District Council. Council's position is clear. We oppose the variation application for discharge treated leachate from the Taylorville Resource Park Limited because it represents risk to the greater Greymouth water supply. Contamination of the extraction bores was seen. It would represent a serious risk to public health, significant compromise to council's ability to provide a critical potable water supply to the greater Greymouth community. I take the council's submission and my evidence as being read. I've tried some. The Greater Greymouth drinking water supplies a significant infrastructure district. It is deemed to be a lifeline under the Civil Defence Emergency Management 2007. It is the sole source of drinking water for around 10,000 people across the Greater Greymouth area, including hospitals, schools, rest homes and businesses. The supply comes from 3 shallow groundwater bores located in Gravel Beach beside the Grey River, with the 4th bore currently being commissioned. All 4 bores are consented. Once water is extracted from the bores, the treatment process includes ultraviolet inspection, chlorination, and pH correction via lime dosing. Whilst this treats for bacteria and protozoa, it does not treat for contaminants such as heavy metals, PFAS, hydrocarbons, nitrogen compound, and volatile organics. The drinking water system represents a very significant financial investment for the community. Current replacement cost is currently being reviewed, but is likely to be in excess of $20 million. Council is currently working towards the installation of a filtration system to assist with the removal of chlorine byproduct production, with an estimated value of $8.5 million over this financial year and next. Council has a drinking water safety plan for its Greater Greymouth water supply, which includes a source water risk management plan. The most recent version of the document is dated August 2024 and has previously been submitted to the Drinking Water Authority to Martha Arrowa. The source water management plan identifies in detail the potential risks associated with the TRP site, I should say, apologies, which sits in the catchment immediately north of the extraction bores. It recommends that further work is required by technical experts to understand A, the geology of the area, including the geological cross sections of the area between the TRP site and the extraction bores. B, identification of geological and hydrological features, including flow paths. C, with the outcomes to provide recommendations on monitoring well locations, following determination of risk. Any mitigation measures considered necessary to remove risks posed by the TRP site to the water supply source water. The Drinking Water Safety Plan and the Source Water Risk Management Plan are currently under review by Council as significant new information has become available since the August 2024 document. Council is also in discussion with Te Martha Arrowa on this matter. The TRP operation sits about 400 metres from the extraction bores, is located uphill, which means there is direct risk of contamination, migrating into the source water supply. Independent hydrological experts have confirmed there are potential flow paths from leachate contamination, including through groundwater, source water, and fractured mudstone. If contamination reached the extraction bores, the supply would be compromised very quickly. Council's main and motto treated water reservoir holds operational storage of 6 to 10 hours, with some minor reservoirs holding up to 24 hours storage. The storage is also dependent on the filling cycles of those reservoirs and a particular time of the event, meaning that the storage could be less. There is no immediate alternative source water supply for the entire Greater Greymouth water supply. If a contamination event was to occur from TRP, Council would need to understand if the contamination occurred from source water or groundwater. Council would need to isolate extraction bores, issue urgent notices to the community, and urgently seek alternative water sources. Realistically, this would not be achievable within the limited timeframes available when consideration is given to maintaining a supply. Major treatment plants would likely be required at the cost of many millions to ensure the removal of specific contaminants, testing and commissioning before normal water supply could be returned to the greater water supply consumers. Whilst Council's submission focuses on Greater Greymouth water supply extraction bores, the Runanga water supply extraction bores are located 1.7 kilometres away on Sid's Road, which is essentially west of the TRP site. Council is working to bring these bores online at present, notes that they are consented also. These extraction bores form part of the Greater Greymouth water supply drinking water safety plan as part of emergency supply. These existing bores are evidenced in the NGO preliminary hydrological assessment report dated September 24, which can be found on page 118 of the recent section 42A report. Given the limited information about groundwater flows, monitoring is unlikely to be a complete solution. The installation of additional wells for monitoring would not guarantee early detection, as laboratory testing and results of testing do take days, meaning by the time results become available, contamination would have already entered the water supply. To date, the applicant has a poor compliance history, with discharges being recorded on several occasions with abatement notices from the West Coast Regional Council. Council considers the explicit prevention of contamination of surface water and groundwater under existing condition 11 to be an important safeguard for the environmental protection of the Greater Greymouth water supply extraction bores. The EPA has already directed alternatives, including construction of additional lines, storage and or removing leachate to authorised off-site facilities. It is believed that further investigation into alternate solutions should further be explored as the proposed discharge to land where contaminants surface water or groundwater could threaten the drinking water source water. If consents were considered appropriate by the commissioners, despite council's opposition, the council would require very strict conditions. These would include, but not be limited to, an independent technical review of the draft discharge management plan, an approval process involving council, regional council, iwi, Paraguay, accredited lab sampling, testing and monitoring, and bonds to cover all risks associated with contamination from the site. These bonds will further need to be scaled to provide all associated costs with any contamination event, including alternative temporary water supply and treatment upgrades. The scale of the bond has not yet been fully considered, but when considering life conditions to avoid effects on the drinking water supply, the bond level will likely be millions. Determination of the bond scale could only be determined once the risk is fully understood and the likely treatment processes are known. Council would further need strict guarantees that contamination could not reach the extraction bores and that TRP's operation would not place council in a position where it could not meet the requirements of the Water Services 2021 or the Drinking Water Quality Assurance rules. Furthermore, the required monitoring is deemed necessary by council's technical advisors and Smarter ROI not result in any additional cost to Greater Greymouth water supply consumers. In conclusion, the council sees the risk to public health, source water security, council's ability to maintain potable drinking water supply, meeting the requirements of the Water Services Act 2021, and likely financial burden on consumers as unacceptable. A contamination event would have catastrophic impacts on the Greater Greymouth water supply. Significant costs would be seen to resolve any issues, and the council would likely face liability under the Water Services Act 2021. For these reasons, council strongly opposes the variation application. Thank you for the time to address the commissioners today. Questions? I do wonder whether commissioners would like me to address some of the questions previously raised.
You'll probably pick up on a couple of those here, so putting the hands of the chair for the moment.
No, we'll pick those up. Can you just explain to me the role of Tomato ROI? What does it actually? What is its role in terms of this specific?
So Tomato ROI, a drinking water regulator, and oversee council and other water supply water suppliers in the production and delivery of water services.
So what's their engagement?
The council is essentially accountable to Tomato ROI for the way it provides the services to its community. So they receive information such as our drinking water safety plans. They review, provide feedback, and ensure that council is doing the right thing for its consumers. It has wide-reaching powers under the Water Services Act and can take action as needed to ensure public health and safety.
So the source management plans, someone need to be approved by them, do they?
Not so much approved. Historically, the safety plans as they were described were approved by the drinking water assessors under the previous regime under the Health Act. However, under the new Water Services Act, Tomato ROI receive and ensure that those plans are of a certain quality, but they do not approve or accept those plans. The risk essentially entirely lies with the drinking water supplier.
And you may or may not know, but in terms of bonds, are you aware of any other situations where a bond similar to this has been included?
No, not aware of it.
Yeah. You've reviewed the JWSs that have been.
I have reviewed at a high level, yes.
And you indicated from the potential program to move forward towards decision making, to inform decision making. Did you have any comments in terms of those matters? Not as an expert, but whether they would help address concerns that you have at all?
That's something that we in the council would need to consider a bit further. Certainly, the involvement of our technical experts in developing or being part of the process for this is certainly critical to council. But I don't have any views. Question.
Can I just talk to you briefly about your level of engagement with the applicant through this process? Yeah, you've provided information what has been requested, I understand.
It's correct, yes. There was some discussion about water quality monitoring data that had been provided through a request through TRP's technical experts or technical support, which council has provided. I guess there was some allusion as to why council didn't provide the drinking water safety plan at the same time. Council receives numerous requests for information, and typically the requests are fulfilled to the information requested. In hindsight,
Did you say did?
Sorry,
I just missed the word you used. Did you say did or didn't relate to the request?
so the drinking water safety plan, I don't believe was part of the request at the time.
Like,
It was directly relating to all water quality data that council held, which was subsequently provided.
And those plans are generally confidential, is that, or not public?
The drinking water safety plans. Typically, they're not published on council's website, or they're not confidential as such, but they're not public either. Council would be more than happy to share those.
So if you get a request for them,
yeah, sure. Yeah. So thank you for your summary here, and it did add a little bit of further information, which was useful over and above your statement of view. So thank you for that, Mr. Granson. So I've got 2 or 3 questions that arise directly from that summary, and then if I could go back to your evidence and then just take you to a number of paragraphs in there and just seek some clarification around those. So just looking at, and we're in the summary at the moment. So when do you expect the fourth book? So this is a simple one. Let's have, when do you expect the fourth book to be online?
So council is working through that at present. Intention to have it up and running before December this year, so it's quite good. That's an effort to support what will be the capacity demands through the summer period.
Yeah. So that wasn't a replacement for one of the boards. What it didn't appear to be giving, the capacity that you needed. So it was added to a lot of capacity in the system.
That's correct. It's not a replacement of an existing board. It's an additional. And the primary reason for that is that as the scheme has expanded in recent years, the capacity needs to meet demand have increased. So historically, we council have relied on 2 bores and had a 3rd bore as redundancy or a standby, if you like.
Yeah.
We were typically seeing that council was using all 3 bores to supply that to meet demand, which provided a resilience issue if we did have a pump failure, as an example. So the put in place to provide that resilience.
Makes sense. Yeah. Okay. For the upgrade, what were you envisaging there? So you talked about filtration. What else? Was there anything else envisaged in that upgrade? And we're now thinking about what other barriers might have been appropriate, but what was envisaged just for that upgrade prior to this?
So the upgrade for the filtration, as discussed, is still working through design at present, but it's essentially it's to provide to contaminants that create or duplicate chlorine byproducts within our supply. So council has for other years through our ongoing monitoring identified that there is chlorine byproducts present, and typically they are at or above 50% of the MAP, and through that process council's committed significant funds to provide treatment upgrades to reduce that.
Right, is the regulator involved in those exceedances?
The regulator, there's been no direction from the regulator, however, they are aware of those and they are aware of council's plans to provide to that treatment process.
So then it's a useful backtrack now then. So given that suite of potential contaminants concern, and there's been a lot of discussion about what's possible, likely in waste material, and therefore what could be presented as contaminant sources could. What I'm thinking about is the water safety plan, drinking water safety plan, and the source water risk management is really the source risk issue now, potentially. What would Tamarau Airways' position be on that and giving direction to what they believe you need? And I take your point about the approval. You know, the new regime is that all risk is with the supplier. So they're not going to direct you unless there are transgressions. So this is more looking forward. So what would you conceive would be needed given that? What would be the response to council now?
I guess I'd be talking hypothetically.
It is hypothetical, only in the sense of that suite that could well be there. VOCs, SVOCs, PFAS, metals, all those things that this treatment plant simply couldn't deal with if it were in the agreement.
Well, I guess my view on that would be that, you know, council would need to seek some more technical advice from supply experts. But ultimately, the application variation was to be approved in some form, then council would be likely in a position of having to address that risk. It's the same as any other risk that it sees within its source water management or drinking water safety plan. As to how, when, and how that could be funded, a huge question, and also a huge ask of the ratepayer in that area, serviced by that.
Oh, undoubtedly, yeah. And those quantum that you stated there are not unexpected. It depends on what the response needs to be. So one of, I suppose there's two aspects that I'd like to ask you about. First is council's liability. And this was actually touched on, and I think we skipped over this, but in paragraph 79 of the legal submissions that we've just heard, and they relate to potential criminal liability, all of the issues that relate to the exposure that council now has, or a water supplier now has under the Act. So, and also the fact that the regulator will now be looking at this as well, because they have the drinking water safety plan, risk management plan, they know what the scenario is, and you get a response from them on that, certainly. So combining those two things, firstly, have you had any feedback from Tamarau yet as to what they think the situation presents? That's question A.
First, I guess to answer that, you know, not specifically on this instance, but the council is aware of the liability, both to itself as a council and staff individually as well.
Yeah,
certainly weighs heavily.
So could you spell out that second part? I think it's worth being on the record.
So Tamarau have a process which ranges a process of investigation that they undertake. There's a raft of outcomes from that. Anything from obviously they find that there's no issue, particular scenario, right through to prosecution under the Act. Prosecution has quite severe penalties, which off the top of my head is many hundreds of thousands of dollars, and that can also apply to individuals if they're found to be negligent in a particular scenario.
So, given that, would this now be on the corporate risk register for this particular situation faced by council or not?
Right now, it is probably not. However, this situation with the application for variation and the swift nature of the situation with the TRP operations is certainly approaching that piece.
Yeah, visits that. Yeah. I've got some more specific questions. So that was just around the, I guess the liability exposure frame, but let's have a quick look. Yeah, I think we've addressed most of these. Yeah, so yeah, this is approaching a couple of areas of detail that I'm interested in your responses to. And I did pose the question this morning, and it relates to, in your view, as a person responsible for the water supply and all that goes with that in terms of the regulation and legislation, what is the appropriate criterion that you would use to assess the risk at the well field? So, and then I've got a couple of associated questions with that, because the response was, well, it would be the NAV. Now I suspect, but over to you, that it is more complicated than that. But what would be the threshold you'd be looking to in terms of Sentinel forward monitoring, online, and then for compliance? What would you be looking at? You can take any contaminant, would be fine. But
I guess so. Our drinking water safety plan uses guidance from Te Mata Waiwai, which is relevant to the handbook for preparation of a water safety plan. So it's a 2019 document. And in that, there's a risk matrix that the council uses to do its risk profile with any particular. In terms of the particular items around our bores, we would need to be in a position that we will well in advance notified of the potential risk. That there's identification of a risk from the source water as it arrives at the treatment plant is not acceptable. At that point, we are significantly behind the 8 ball in terms of responding to an issue. We would need to have clarity well in advance of anything reaching the bores.
And was that the reason that response, and I did read what you suggested specifically in the source water risk management plan?
Yes.
Around Sentinel wells and the suggestion about that, was that to achieve that objective, is getting some early warning on
that was
contamination?
One of the options that was considered by council for some technical expert around how we might deal with that risk profile.
Yeah. So say if you took an intractable that you treat, and there's quite a number of different things now suggested as possibilities. But if you took PFAS as one, it's because it's just been one that's been discussed as an example. So how much early warning would you need to have on a contaminant like that, which is possibly in the source, not definitively, or possibly, how much early warning would you need on that before it becomes absolutely critical in the supply?
I guess we'd need to understand the level of concentration of that contaminant, what its effect would be on the water supply, and how.
Would it be any level? Would it not be any level? Would that not raise a major flag if it was detected?
I would, yes, the answer would be yes. So it's about identify that early, insofar as that it's not in the supply and how it could be protected against before it reaches there.
Yeah.
It's the case of it arriving at the borders or being identified in the supply is too far down the track for us. We would need to be able to essentially remove that.
Yeah.
From
So,
the source.
so what would be your thoughts about how you might do that? Or do you think that would be with others to allow you to do that or provide you with the means of
I
doing that?
think we would need to take further technical advice on
Yeah.
it, which we could do and provide in detail to the commission.
Yeah. Okay. Yeah, so that was all the questions just out of your, you can just give me 2 seconds. That was worked out. Thanks, Chair. He did ask you about the conferencing, the results of the conferencing that have been undertaken with the experts. So that hasn't changed your perspective. I see from the summary that your position is largely the same.
It hasn't changed that point at this stage. It is that there is too many unknowns at this point.
Yeah. Okay. No, I inferred that. Yeah. We've already talked about the legal responsibility, and I assume that you are the person. You have a delegated authority for the supply, that you would be one of those persons that could be potentially liable under the Act.
It's entirely likely, yes.
Yeah, either one way or the other, you probably would be. Yeah, and as you say, the penalties are substantial now. Post North, there, it's a very different world. And it's not a best endeavour requirement now, as it was under the Health Act. It's an absolute now. So that situation has changed substantially. So that's accepted. You mentioned about the distribution network, but what would be your response for a transgression? Is it possible to even maintain any part of that supply? You talked about alternatives. There's no split. There's nothing in the distribution system, or nothing that would allow you to mitigate the effect of a transgression for which you need to shut down.
A transgression, and from the point of view of some of the contaminants that we now sort of aware of, that would be essentially a loss of supply scenario. Assuming that there was identification early enough, treated storage within the system would be available. It's possible that may not be available, it could already be contaminated. And I think I alluded to, we somewhere between 6 and 10 hours for a major treated water reservoir. The reality is identifying and place alternate source water for a scheme the size of cheaper at that time.
You have other obligations for emergency supply as well?
We do. I use the supply boards. So there is a small part as an alternative, about 15 litres a second from those particular pools, assuming they are not affected as well. But the overall supply, on average, is about 120 litres a second. So we're fairly far short of that.
Do you have you lose that supply during flood event?
Not so much. Obviously, we have our fair share of flood events in the Grey River, and the what was bank filtration under the old drinking water standards is has worked well for council. So we do see some spikes in turbidity, up around that 1 to 2 NTU. But in terms of a supply, we can manage bores to continue supply through a flood event.
Oh, okay.
The catchment is
helpful.
the catchment is fast moving catchment, so floods do come through quite quickly.
That's not the case for a lot of other now it just applies to you but being up through games. Yeah,
So-
3-4
so
days. And I wonder
typically-
what the effect it would be for you, but you're saying that enough.
So typically, all of our bores have somewhat different characteristics. So our bores 1 and 2 are typically favoured in the flood event, the downstream bores, whereas our bore 3 perhaps has more effect.
As a wood supply operator, have you formed a view on the relative contributions of wood water? There's been a lot of technical debate about whether or not upgrading groundwater, surface water derived as opposed to straight from Grey River water. Have you formed a view about that? Do you
Yes.
have any information about that would give you an indication what that proportionality would be?
So there is information within the drinking water safety plan that suggests that bore 1 has a higher influence from groundwater than the other bores. However, it doesn't preclude groundwater influence from the north to the other bores.
And all ones downstream as
The
well.
ones downstream.
Yeah.
Sorry. Yes.
So would you suspect that being the case that would be potentially vulnerable to contamination?
That would be.
You think the technical information would support that too?
From what I have read, yes.
I think we're getting close to the end of this, but yeah, sure.
Just so I'm clear, the bores, can they operate individually?
Bores.
So could you rely if bore 1 was infected, could you rely on bores 2 and 3?
Historically, yes, but under the current scenario with capacity for the largest line, we are reliant on 3 bores at any one time. Bores do ramp up and down in terms of their production levels, but we are more consistently running 3 bores at any one time. But this is supporting the additional bore that council has constructed.
And the Runanga bores, are they operational?
Currently, the Runanga bores are only operational in terms of turnover to waste essentially. But council is working through the commissioning of those bores at present. Coal Creek, Runanga, Denali, Rapahoe areas in an effort to take some pressure off the facility during the summer period. Recently, there had been some the drinking water authority around meeting a slightly higher treatment level in terms of chlorination and UV treatment. And in order to achieve that, there is further pressure on the treatment facility, which has led council to the point of bringing those bores or considering bringing those bores online.
Can I ask, paragraph 46 in your evidence, do you have that? You refer specifically to the 2 abatement notices. as we are seeing each day.
Yes.
My question about that is, what response did that trigger for the supply? And in relation to this water supply?
That particular event, I guess, opened the water supply's eyes a little bit to the wider risk of the TRP site. The drinking water safety plans are a live document as such, and continually seeing dates as the catchment or risks or operations change. These events ultimately led to the August 2024 update of the drinking water safety plan. In terms of response, it was understanding the outcome of what was observed, and the I guess the suite of results from the testing that were captured by the regional council and others.
So for that technical proposal for additional forward early warning, was that a response to those, or what?
You could see that as part of that response, yes.
And your evidence is that there was no action on that because wasn't it the premise was that would be TRPL that would look to try and mitigate that potential effect by installing some wells which would allow you that early warning?
That was our understanding at the time, yes.
Yeah, and that wasn't progressed at all.
I don't believe so.
I think that's 49B now. I think you've mentioned some discussion about the condition of the liners, and that's already been talked about this morning briefly in legal submissions. Do you have any evidence for that, or is that just simply putting two and two together that there were discharges that resulted in abatement notices and observations about how excavators were being used on site, or is there any definitive? And I'm not excluding cell 80 because that's a different situation, but do you know that there are defects in the liners or have evidence of that?
I personally don't have evidence to support there's breaches in the lines. However, I've been fortunate to visit the site myself, and certainly based on my knowledge of landfill construction, as part of my portfolio basis at council was managing council's own municipal landfill, and knowing the level of protection that council builds into its own landfills, there's certainly questions about the design and quality of the land, the cells of TRP.
So this comes from your own observations. I think some of the other evidence relies on Rook's technical assessments. So I think probably those can go to her. We will be able to speak to her next. But sort of asked about. So I guess my big picture question with this is that, given the current scenario, and if this discharge consent were granted under conditions as we've discussed and the process that's been envisaged, do you believe that GDC can meet its obligations under the Water Services Act?
I would probably need to take advice on that myself. In some respects, the answer will be no.
what would they?
And that would be from the point of view that the risk level within our source water management plan would change and would have to be reviewed. And on that basis, it would be reasonable from the Drinking Water Authority regulator, I should say, to then require council protections in place. And the affordability of putting those protections in place would be the key issue, I suspect.
So two aspects, one in relation to the regulator's perspective and response, and the other just the affordability of the treatment mitigation that would be required to bring the safety to an acceptable level. So, and the adjunct question to that then is, how did you, in the source water risk management plan, in terms of likelihood and consequence, where are you placing something like a VOC, a benzene, or a PFAS, or something that's highly mobile, intractable, difficult to treat? Where are you placing that in terms of consequence? And vice versa.
Yeah, so that work is still yet to be completed. So now that we understand what those contaminants look like, as part of the review that council is currently undertaking, we'll have to identify that risk level. But my assumption at this point would be that it would be higher than moderate, which is the current risk level. Safety.
You wouldn't be prepared to say if you had a PFAS in your supply, what that consequence would be.
So catastrophic.
All right, well, that's it for my questions, thank you.
But that last question, that would be at any detection.
Oh, I framed it as it's actually above what you have, but yeah, that's a good question though.
And I would need to take technical advice on that as well, but I wouldn't at this point say at any level.
You know the discussions we had with council in relation to. Do you have anything to add to that discussion?
It's consultation around the source water management plan. Certainly can add some detail to that. Look, in terms of consultation, obviously I'll need to put some context around this, but there has not been consultation with TRP, the source water risk management plan. The reason for that is, as alluded to earlier, that safety plans are a live document. And up until around early mid-2023, the facility was known as something in our catchment. However, it was deemed to be of lower risk because it had the condition 11 supporting the no discharge of contaminants. Beyond the identification of discharge, that changed the scenario for council when we had, which ultimately led to the most recent version. So as the risk level changes, the amount of detail and investigation also changes. I will say that into the future, obviously consultation will be needed, but the swiftness of the change and the risk level hadn't permitted that previously.
But there's been no consultation at all.
This is specifically related to source water risk management.
Yeah, where the requirement comes from, yeah.
Just unclear in terms of the upgrade block coming in, been discussed, but it's a side clear in my mind. The upgrade that you've got program is a program now.
Yes.
So in terms of your treatment processes, they're going to be focused on particular matters, are they? The upgrade of the treatment process.
That's correct. Yeah. So the filtration system is specifically to reduce tannins in source water, and that is because of they lead to chlorine byproducts being produced through the treatment process, and as I noted earlier, those chlorine byproducts do exceed 50% of the MAV quite typically, and the council is working to address that.
Just on that point, sorry, so the way it has been discussions about the MAV. So in terms of criticality, you would say that any detection would be critical. Is that correct? Because half MAV is often a trigger, certainly, and that the regulator starts getting interested even at half MAV. So it's important to place this, I think, as to where this consequence actually is fully triggered for you in terms of the supply impact.
I guess that is relative to the contaminant that we are discussing. You know, where there are maximum allowable values detailed in the documentation for council to follow, then there's reason to talk about 50% of the NAV as an appropriate level. However, the level of consequence potentially increases significantly with some of the contaminants that we are discussing here today. So my view, you know, to be, obviously council needs more technical support on it, would be that any identification of the contaminants, PFAS as an example, would be an issue.
They haven't been detected to date, have they? You just to be clear, you haven't detected any of those, anything in the DOCs, some of the organic suite, the more intractable organic chlorines.
Some of those items council doesn't test for as well.
Yeah.
But where we do, I don't believe there's any issue at present.
Yeah, just for balance, that this is a hypothetical discussion here about those.
Commissioners, just on that point, just to see whether or not you think what this can get clarification on that. But I guess if we are talking about the baseline testing and stuff, it would be important to know, I think, in terms of the conversations in terms around bonds and all the rest of it, what the actual baseline is for the water that's currently being tested at the site, and where that sits in terms of the types of contaminants that are already tested for, have been, just so we have a better idea of what that baseline is as well compared to the source baseline as well.
Yes.
So I don't know in terms of issues of any of these, but it's going to assist them.
Did you hear that discussion?
I believe so. And council has a suite of testing that it undertakes and data for many years that I believe we've already provided to TRP, but is available on request. It's not a problem.
You have a question?
Yeah, that has been a question. I'm just thinking about in terms of the question you just asked about.
Yeah.
Other things that can now used as contaminants of concern.
Yeah.
Whether or not there's actually those, because I don't believe those test results do include those contaminants.
Yeah, that's right.
Understanding.
Yeah, I understood the reason. Interesting. Yeah.
Okay. Yeah. So they're not tested for at the moment. The contaminants of concerns are not tested.
Even in an annual,
Need to double check.
it's a pretty comprehensive suite when you go back on an annual basis. Anyway, it's I suppose we can address that.
Yes, no, absolutely. I just wanted what we had assistance.
There is a list next to the drinking water safety plan for annual testing, and I don't believe it covers those contaminants that have been raised over the last 2 days.
Thank you very much for your assistance. For the question we had.
That'll be just fine, thank you.
And then this.
Oh, my sister.
We have all done.
Yeah, yeah. That's what I've done.
Okay, thank you.
Welcome. Now we've received your summary of evidence and some other documents, and if you can commence by taking us through the summary from paragraph 3.
Good morning, or good afternoon, everyone. I'm Natalie. I'll proceed with my summary of evidence. In paragraph 3, the updated HA contains information gaps that affect effects as discussed below. On the basis of the limited well construction and bore log information presented in the updated HA, I cannot confirm the appropriateness of the existing groundwater monitoring wells containing representative data with respect to A, groundwater levels and therefore flow directions, B, groundwater quality, and C, geological properties of the formations, such as hydraulic conductivity. It is unclear if preferential flow paths exist within the Pleistocene gravel. I note that the Pleistocene gravel is not homogeneous, and preferential flow paths within zones of higher hydraulic conductivity could theoretically occur. These flow paths, if present, could influence groundwater flow directions, discharge points, and travel times for contaminant transport, and could alter the assessment of effects. It is unclear if fracture flow systems are present in a Kayad formation, which may increase infiltration from the soakage area and connection between potential receptors. The investigations undertaken to assess the properties of the Kayad formation are very limited, and some of the investigations, slag testing and testing, have produced conflicting information warrants further investigation. There are potential contaminants that have not been tested for in the proposed discharge or in groundwater and surface water, and these should be tested to establish if they are present prior to discharge occurring. As a consequence of the information gaps, the existing, that is the baseline groundwater and surface water quality conditions, and the condition of the discharge water have not been adequately established. I note the baseline condition of groundwater may show some level of pre-existing contamination due to other activities at the TRPL site. If so, the assessment of effects would need to consider potential changes to the fate and transport of pre-existing contamination, if present, as a result of the discharge. The Hantush model scenarios indicate the potential for groundwater flow away from the proposed soakage area in all directions. Mounding may therefore induce groundwater flow south towards the GDC supply bores. The Hantush modelling includes a range of assumptions that may not reflect the site conditions, such as A, the Kayata formation is impermeable, i.e. does not transmit water. B, soil permeability testing of the unsaturated gravel in the proposed soakage area has not been undertaken, and a hydraulic conductivity value of 1.96 meters per day has been selected for the modelling to allow for a discharge of 300 cubic meters per day. C, dissipation, that is depletion of the mound. This cannot be accounted for in the model. Overall, I consider the extent of mounding that might occur under the proposed operational constraints is unclear. I consider that the contaminant freight and transport modelling presented in the updated HA is of little utility given A, the worst case contaminant concentrations in the proposed discharge are not adequately characterised due to the omission of testing for some potential contaminants. B, the existing conditions of groundwater are not adequately characterised due to the omission of testing for some potential contaminants and the uncertainty generated from the lack of clarity which geological formations are being monitored by the monitoring wells. C, the information gaps in the understanding of the site-specific hydrogeology. With respect to the contamination conceptual site model, there is at least one potentially complete pathway for contaminants to reach the GDC water supply bores. The pathway is groundwater discharging into the roadside drain to the south of the TRPL site, then transport and surface water to the Grey River Terrace and seepage into the Holocene gravel. The roadside drain on Taylorville Road crosses beneath the road near sampling location TRD2, which is identified on figure 15 of the updated HA. This flows into an unnamed creek referred to as No Name Creek 2. No Name Creek 2 is located east of the GDC water supply plant, and its proximity to the GDC bores is shown on figure 10 of the updated HA. Migration through the Kayata Formation presents another potential pathway for contamination to reach GDC's bores. Because of the information gaps, I conclude that the assessment presented in the updated HA is insufficient to assess the potential effects on the GDC water supply. I consider that additional site investigations are needed to address information gaps to enable a suitable assessment of the potential effects. Now into the next section, expert witness caucus. On the 28th of August 2025, I was provided NGO's draft temporary discharge monitoring plan dated 26th of August 2025, that is the DMP. On the 1st of September 2025, I met with Mr. Berry, Mr. Griffiths and Mr. Stephens, and we produced our joint witness statement, the JWS. The points of agreement are outlined in paragraphs 8 to 12 of the JWS. I note that the comparatively shorter list of points of disagreement does not suggest that there were few points of disagreement. Rather, it is a reflection of the limited time available and that the focus for the caucus was seeking points of agreement to address the Commissioner's directions outlined in Minute 5. In the caucus, it was generally agreed that a pathway for contamination to GDC's bores existed. That is, the pathway via discharge into the roadside drain and transport in No Name Creek 2. Refer to paragraphs 9 and 10 of the JWS. The parties disagreed on the level of potential effects via this pathway, paragraph 13 of the JWS. The parties agree that there are potential contaminants that have not been tested for, paragraph 12 of the JWS. The parties agreed that in theory that it could be feasible to manage the proposed discharge via consent condition for a discharge management and response plan. The plan would be informed by further investigations and subject to independent review. However, the participants did not have sufficient time to consider the draft wording for consent conditions. Refer paragraph 11 of the JWS. NGO supplied an outline of suggested consent conditions, which are attached to attachment 1 of the JWS. The outline indicates the preparation of a groundwater discharge monitoring and response plan, a GDMRP. A GDMRP was not available for the caucus. My understanding is that the GDMRP will supersede the draft DMP. In paragraph 18 to 24 of the JWS, initial comments on potential conditions were provided. I note these are comments and not proposed conditions, as reflected in paragraph 17 of the JWS. Due to the limited time available, we anticipate the content and the wording of these conditions to be discussed and refined. Other documented points of disagreement included A, fracture flow in the Kayata Formation, where Mr. Steffens and I considered insufficient investigation has been completed, refer paragraph 14 of the JWS, and B, the ability of the Pleistocene gravel to accept the volume of the discharge, refer paragraph 16 of the JWS. Into the next section, site visit. I visited the TRPL site, observed the roadside drains near TRD2, and visited the vicinity of the GDC bores on the 2nd of September 2025, accompanied by a representative from NGO. I thank TRPL, NGO, and GDC for enabling the site visit. My visit to the site and surrounds does not alter my opinions formed or conclusions outlined in my evidence. Next section, oral evidence. In oral evidence, Mr. Berry noted that all models carry a level of uncertainty. That's paragraph 10 of his summary. I contend that the uncertainty raised by the information gaps in the hydrogeological assessment is not simply uncertainty related to a model structure and parameters. There is information that would have been straightforward to obtain to inform the assessment, but was not. For example, by testing of proposed discharge water for the potential contaminants, or installing new monitoring wells in the south of the site between MB3 and MB4 to better assess the groundwater flow directions. Instead, the assessment relies on using modelling. In oral evidence, Mr. Berry provided estimated volumes of fracture flow as lines of evidence for there being no viable pathway via fractures in the Kayata Formation. That is paragraph 16.1 and 16.2 of the summary. The presumption that either a 3 centimetre or 5 millimetre fracture bears any relation to the site conditions and volume that may be transmitted by the Kayata Formation is not supported in evidence. In the Commissioner's questions to Mr. Berry, there was discussion regarding the base of the landfill cells and their interface with groundwater levels. I note there may be local effects on groundwater flow directions from groundwater discharging into cells, leachate discharging from cells, and leachate pumping. With respect to this consideration, during my site visit, I observed the proximity of the proposed cell D to the proposed soakage area. Cell D is an open, unlined gravel pit. I note that seepage into cell D from the proposed discharge had not been considered with respect to the mounding effects. In oral evidence and responses to the Commissioner's questions, Mr. Berry noted that the Pleistocene gravel is heterogeneous, i.e. it has varying properties, and anisotropic. It has directional differences in properties. Mr. Broughton also referred to differences in the gravel subunits in his oral evidence. These considerations are important with respect to the potential for preferential pathways, which do not appear to have been considered in the hydrogeological assessment, and to the idealization of a homogeneous unit in modelling scenarios. In the Commissioner's questions to Mr. Griffiths, there was discussion of the possible PFAS sources in construction and demolition, that is C&D, waste. To assist the Commissioners, I have attached a study of PFAS leachability from various C&D wastes. In that study, which is an international study, C&D waste in unlined landfills is considered to pose a similar, if not greater, PFAS leaching risk than municipal solid waste landfills. And that is to say that the concentrations in PFAS that are leached from those landfills can vary widely. Conclusions. There is a generally agreed pathway to the GDC bores as outlined in the JWS and my evidence. The understanding of groundwater flow patterns at the site and the potential effects of mounding from the proposed discharge are limited by the hydrogeological characterization that has been undertaken. The quality of the proposed discharge and the baseline conditions of groundwater and surface water have not been adequately established. On the basis of the above, I consider the proposed activity could pose a risk to GDC's water supply. The yet to be formed draft conditions will include further investigations, which, in my opinion, could address information gaps I have outlined in my evidence. I note that the results of further investigations could indicate that additional subsequent investigation is still needed to assess the potential effects of the discharge. While I cannot comment on the consentability of the approach pondered in the JWS, I do note that an estimated timeframe was not included. To assist the commissioners, I have provided my opinion here. Based on the suggested outline for conditions and initial comments in the JWS, I consider it could take up to 3 months following granting of the consent to complete the further investigation and interpretation and independent reviews before the discharge may be able to commence. This estimate does not account for the time before consent execution to prepare, review, and agree on the conditions. I consider that the crafting of clear, workable consent conditions is likely to be difficult and take some time given the breadth of items to be included, which are not limited to the suggested outline provided by NGO or the initial considerations in the JWS. I consider that the independent review process may result in disagreements over the interpretation of data collected, which could affect the assessment of risk. My reason for this consideration is based on the extent of differences already documented in evidence and the iterations of review already undertaken by Mr. Stebbins and me. I know that the timeframe would also be contingent on other factors, such as A, whether the detailed design of the soakage area changes the investigation approach, B, contingency for additional subsequent investigations, and or further pre-treatment of the discharge water if new contaminants are identified. Thank you.
Clarification, the human hazardous material documents that you've been provided with your.
Yes, that's my attachment.
And it's anything in particular that was for.
As I noted in the summary, that the authors consider that C&D landfills could
That's the.
have similar or greater leachability compared to municipal waste
Yes.
landfills, and also that they specifically study particular properties, leachability from particular types of waste. So they tested carpet, they tested drywall, so gyp, to see what might be more leachable, and they showed that whereas the PFAS content of some products might be high, didn't necessarily mean it was more leachable PFAS, because of course PFAS compounds comprise 3,000 plus different compounds, but they did find that drywall, so gyp in particular, had more leachable PFAS compounds in it.
Thank you, Mr. Rock. That was a very useful summary. And it did, as other summaries have done, started to build on what has been achieved in the last 2 days and prior around focusing what's in some of the areas of disagreement that have been narrowed or not. So I have a few questions for you, but I don't intend to go into a lot of the detail that's in your statement of evidence. I think it stands on its own feet. It's very detailed and it's there for the record, and it's there for the applicant also to consider in terms of the recommendations that you have provided to resolve some of those information gaps and uncertainties that you've identified. So my questions are going to be more about the consequence of that, the implications of that, and whether there's a resolvable way forward as a consequence of that evidence. So just to preface how I go to in the process, I'm not going to ask you about 4, 9, falls on, anything like that. So, so the first of them, there seems to be two issues, and I just want to get your agreement on this, is that at issue, it falls into two camps. Either it relates to information that supports a contaminant pathway, and you and I know exactly, so we can use the terminology around how these are assessed, pathway as opposed to the source and the receptor. So there's been a lot of discussion and dispute around uncertainty about a full and complete viable pathway, number one. And then secondly, there has been debate about what is the consequence of that. So what is the nature of the potential source contaminants? How would they migrate, and what effect that have at any receptor, including the drinking water supply? So would you agree it's sort of broadly in those two?
Yeah, so
Yeah, okay. So so that being the case, what I'd like to understand about, and so focusing on the pathway at the moment, and you've discussed a complete pathway, and you've discussed the what's understood about the nature of the Pleistocene gravels, the mudstone, and intervening surface water to complete that pathway. So have you provided in the joint, in the caucusing and feeding through the joint witness statement, the information that would be needed to provide certainty about that? You've given a time frame for it, but is it your understanding that now the experts could undertake the investigation, should be that be the case, to establish whether that pathway is complete or not? Some of it looks very difficult, some of it looks quite straightforward, and some looks quite difficult to achieve. So I just want to get your perspective. Is it an achievable goal within that 3-month time frame?
it's possible. It depends on the results of the investigation. So it's contingent on what the findings are. And I've discussed in my statement of evidence
You do.
the process of a hydrogeological assessment being iterative, being informed by the results that are collected. And in this case, where we are considering doing further investigation as part of the consent conditions, the results could end up being, I suppose, acceptable in that time frame. It could resolve enough issues, but it also could not.
Yeah, but contingent on those steps, and you did set that out quite clearly in your evidence. So that was good. Now, would that, given that was successful within a time frame, would that be also acceptable to GDC in terms of understanding the risk to its supply?
I can't necessarily speak to what GDC would consider acceptable. I'm not involved in the DWSP or the source water risk assessment or what.
Yeah, so maybe just spin the question a little differently then. So if it were successful, would your advice be to GDC that would satisfy the information? And
Yes, if I was satisfied,
yeah,
that would be my
you
advice.
would provide that advice, yeah. So on the other side of the equation then is the modelling, and so and I guess I might touch on the mounding situation. There's a lot of debate about that, but I'd like you to confirm whether or not, in relation to the two aspects that we're dealing with here, one is mounding. Been a lot of assessment about that, debate about appropriate parameters, hydraulic parameters that should be used to establish that capacity, all those issues. Then there's the other side, which is the contaminant fate and transport modelling. So in your mind, which of those two is more important here to understand effects?
In my view, it's most important to undertake actual hydrogeological characterization that is sufficient for progressing into doing modelling.
Both types of modelling, you mean the Hantush and the risk five? Because I'm going to ask you about them both.
Both of them are assuming that the gravel is one homogeneous unit, which in evidence is presented otherwise.
And I
So
think
it's this idealized presentation, and the risks of the idealized presentation, or perhaps the consideration of that what was considered to be conservatism may not actually be as conservative as if there are preferential pathways in the gravel.
So is that the result of not having sufficient empirical data to support the models? So you don't have a fundamental concern with the fact that essentially analytical solutions have been applied here, as opposed to formula merit. So I'm good. Without getting into a deep dive on that, I'm seeking your professional opinion on whether those models, which are essentially analytical, are appropriate in this situation if the empirical data is there to support them.
For the soakage pit, using a simple Maoni model, would be a common approach.
But sufficient. Yeah, I know it's common.
Yes,
but is it
potentially sufficient based on the data that's been empirical data, hypothetical empirical data we're talking about, because the collection of additional data may show that there's a fracture flow in the Kayata, and therefore considering it impermeable in the Hantush model is not appropriate.
Yes.
There would be infiltration into the Kayata formation from the discharge. And I would just like to stress that it is the discharge as it is proposed to be undertaken, that is 300 cubic meters per day. If the detailed design of the soakage pit changes, that may change the consideration of whether a simple model is appropriate as well.
Yeah, so it depends. Yeah, and there's always that. Yeah, and the data may send you in a different direction, because if it's the less uniform it becomes, the more the analytical model becomes inappropriate.
Correct.
So it does depend. That's right. So, but you're broadly comfortable. There's a reason I'm sort of exploring this area, and I'll explain that in a minute. So you're broadly satisfied, all things being equal, with the Hantush model. In the fate and transport modelling, was I correct in understanding from your evidence that you had a fundamental concern with the risk 5 model, the application of that?
I have a fundamental concern with respect to the contaminants considered. And so so they hadn't, so the contaminants had not been tested for in discharge water, and that may include PFAS. And risk perhaps is not a suitable model to use for PFAS.
Oh, okay. So it's only becoming potentially unsuitable because there's contaminants that it can't model effectively. Is that the?
Yes, and the way that I laid it out in my evidence when I said that the risk modelling was of little utility is.
I was thinking that directly.
Yes, is because of the lack of understanding of the hydrogeology and all the consequences of that. So again, we're in the same situation as the Hantush model in that it's assuming a homogeneous layer, assuming no fracture flow, and then assuming concentrations of contaminants that, as Mr. Stephens presented, weren't necessarily the highest, but only looking at specific contaminants that risk can handle, but there have been a whole suite of contaminants that haven't been tested for.
Yeah. So I was trying to
considering baseline conditions.
Yeah, no, I was trying to separate those two things about the input parameters and the programs model. So you're saying then that if PFAS is considered to be a contaminant concern, which now appears to be accepted by the experts, that risk 5 is or isn't an appropriate model to assess the transport of.
Well, that's a hypothetical scenario because one, PFAS has not been confirmed to be present, and it has not been presented in the assessment that they would have tried to use risk to assess it.
Yeah, but it is quite feasible though that if testing of more definitive testing of source confirms that PFAS is present, and that's not impossible, then the response to that would be under this regime to go back and review that, use the modelling and try and understand, okay, what would be the effect at the discharge points as opposed to the source. So what I'm trying to get to, have we got a tool here that we can use for this purpose or not?
My understanding of the most up-to-date version of risk is that it does not consider PFAS compounds.
So how then would the applicant back calculate acceptable source concentrations then?
I mean, there are other alternatives, like we see in the Rebecca model. By entering chemical data into risk, it could potentially be adapted for use. It's just not like so much off the shelf solution to be able to select the various contaminants.
You'd be aware that some of the other experts have focused much more on the appropriateness of the parameters as opposed to, I don't think that any other specialist has commented on the appropriateness of the model. Would I be correct in that? Yeah.
I think so, and I think that stems from my position that I think I put forward quite strongly that the characterization of the hydrogeology is inadequate, and thus using modelling, but we're not understand, like using a simple model when the system may actually be quite complex and it's not known is not appropriate.
Okay, so you would maintain that as a default position at the moment, that there is
Until further work is undertaken.
Yeah, not so for that. Yeah, okay, so would that be correct? That we can use the Hantosh to understand variables.
Yes, I mean, the Hantosh model does give an indication. It is limited by its assumptions.
Yeah, okay, because this is quite important because it's going to become part of the response strategy, and to understand what the local effects are of any detected contamination if it's found. And that this will be the go-to mechanism, because it won't be observed, say, at the GDC water supply. It'll only be on site if it's found there, and then through time, you've obviously with a complete pathway, then you've got potential. So that's what I'm exploring. Is it an appropriate tool in the consented process that will be protected with this?
Yes, so as we know, the draft conditions have not been formed. Yes, there are some initial conditions, JWS, that refer to risk modelling. Mr. Griffiths raised in his oral evidence yesterday the potential for, that if PFAS were found, that pre-treatment on site could be potentially undertaken before discharge, and therefore the modelling would not be relevant for PFAS.
Right, yeah, that's provided it is not. Yeah, okay. You've talked about the pathways here. Yeah, I'm just trying to understand. You've mentioned about the influence of the Kayata formation. Yeah, understanding any complete pathway, does that need to be understood, the nature of the potential for fracture flow? Or are there scenarios where that's not relevant? But I'm talking about contaminant pathways.
Mm-hmm. Yes, it does need to be further understood. When I did my initial review in June to support the submission, I outlaid some recommendations to assist WCRC, to assist NGO, and what I was looking for another review of the HA. I think that the argument about chaotic formation could be potentially informed without further field investigation if there was documented evidence of the condition of the core that they intersected during drilling.
Yeah. Which didn't.
Which doesn't exist. There is that one packet test in cell D, and then the failure on Taylorville Road, MB20.
Given the results of the packet testing and the Luchon test done there, I mean, are you confident that investigations can be reconfigured so that the information would be changed? It's incredibly difficult to do almost in any country, isn't it? Whether you're doing that in basalt grade or trying to establish or Hugenbrei, it's very difficult testing to do. So are you confident that that testing could be specified to get the information you need about the incident?
I think so. Another option to the packet testing is doing slug testing in wells that are springs of chaotic formation.
Yeah, I saw your suggestion about that. Was that uptaken by the other experts to look at intervals as opposed to just?
So initial consideration in the JWS is to doing multi-level wells. The formations targeted by those multi-level wells were not discussed in detail.
Right. That's something that could be revisited, just to provide some confidence that really it's in the balance, we're going to get the information we need from this. Because if you looked at the testing to date on the Luchon testing, you wouldn't be confident almost about any of that information. Potentially one borehole seemed to produce reliable results, and that was, but the others were not.
That's correct. Just one result.
Yeah. I think I'll address that too. Yeah, I did make a note, just as you discussed in your paragraph 31 there, and it really you've picked up on my question at Mr. Berry about relative levels and cell inverts. But you were aware that cell D is to be lined.
I understand that that's not before the discharge occurs, though.
No, but I took it from what you're saying. So hang on, what is your point there then? Because you were just saying that, is it in relation to the proximity of the infiltration basin? Is that a concern? Because you just described it as a large open pit, but
Yes,
won't be a large open pit.
And I note that seepage in cell D from the proposed discharge had not been considered with respect to mounting effects.
Right. Okay. Yep. Check anything. I'll just go back to your statement, just see if there's any. I don't think there's anything that we haven't traversed, but I'll just check. I was going to ask though, was there anything about Mr. Perrin-Smith's discussions about risk and some of the responses there that made you think about some of the advice that you had given in regard to that? And that was looking from an operational perspective and the vulnerability of the supply. It didn't change anything about your advice now or what your advice would be in relation to contaminant modelling. Do you understand what I mean? Because
I think I understand.
Outlining is a very high level of criticality.
Yes,
So
I think I understand.
It stakes a high kind of scenario. So
Yes, I think I understand what you're asking. I would put forward that the scope of my evidence is related to this proposed discharge. And that I acknowledge that, as detailed in other evidence, it would appear that there's discharges or from the other operations. So the question of testing in GDC's bores for potential contaminants, I consider that would be best informed by TRPL advising what contaminants are confirmed to be in the discharge, so that then GDC can test.
That makes sense. Okay, thank you, and that was, so thank you.
No, I don't have anything further to on that. We'll take New Zealand to come back at the 30-year schedule, so we'll do lunch break.
Yeah, one thing.
Sorry.
I'm here.
No.
It's probably the one thing. Otherwise we can go back and find. We'll get the portal going, guys.
All right, we'll get underway again. And we're now at the stage of proceedings where we're here, we board officer and supporting the experts.
I think we'll go with Carl Stephens first on hydrogeology and then Jared on ecology, and then I'll wrap it up.
Yep. Okay. So just before I get underway, I just wanted to is where there is a misunderstanding with respect to a statement in my evidence. So that is in paragraph 49 of Mr. Griffith's evidence. He references paragraph 169 of the section 42A report, and indicates that in my evidence I state I consider the effect of the proposed discharge to off-site water quality to be less than minor with respect to the town drinking water supply. So that's not actually quite correct, and I think there's just a bit of a mix-up in the section 42A report.
So what?
So it's yeah. So if you go to the section 42A report in paragraph 169, the statement is the risk posed by the proposed discharge to GDC's drinking water supply has been central to the assessment of the application undertaken to date. Mr. Stephens has concluded that the effect of the proposed discharges to off-site groundwater quality is highly likely to be less than minor. And I just sort of did a search of my evidence because I thought I didn't think I said that. And I think it's referring to paragraph 51 of my evidence.
Yeah,
And
Got your paragraph 51.
yeah, so if you actually just kind of go up halfway through that paragraph, it says, based on this explanation, NGO considered there is no hydraulic connection between the site and the off-site Holocene aquifer, the gravel deposits, blah, blah, and the effect of the proposed discharges to off-site groundwater quality is highly likely to be less than minor. So that's actually a statement by Mr. Griffiths. That's all. So moving on, really overall, I feel my evidence is relatively unchanged. And I continue to consider there's, at present, there's inadequate information to confirm the quality of the discharge water.
Carry on, do we have a summary?
No, sorry. I think none of us have an actual summary, do we? That we provided.
I guess, sorry, some of our statements are a response and kind of a moving feast as evidence been presented to us.
Okay. Be quite happy to provide a written summary as well. I think the audio is being recorded, so we could take the audio and write it into a statement.
Yeah, but the direction included from all experts, but we are where we are, so we'll just carry on.
Okay.
Yeah, apologies for that.
No.
So I continue to consider there's inadequate information to confirm the quality of the discharge water, confirm with satisfactory certainty that there is no or very limited potential for fracture flow, contaminant transport by the Kaiata mudstone, confirm the potential concentrations of contaminants at the nearest receptors, and confirm also elevated concentrations of metals, which were copper, lead, zinc, measured in the GDC treatment plant, and yeah, their source. And further to those issues, I consider the available information relative to the hydraulic conductivity of the Pleistocene gravels indicates only very low quantities of water are likely to be accommodated by that strata. The hydraulic conductivity value derived from the closest site, which is MB13 monitoring bore, which is right beside the, or very, very close to a discharge, proposed discharge location. If you use, that conductivity value, it indicates that the potential discharge volume restriction of only around 12 meters cubed per day. And so they they are all similar findings to what has been stated in my evidence. But I do note in terms of new things, I guess, that have come up, just I had cited a plan just this last week, which has elevation contours and streams on the upper terrace. And I just noted that one of those streams, the source of one of those streams is right beside the discharge location, and that stream heads directly. Sorry.
What figure were you?
Yep, it is.
As long as you'd be able to tell us that.
Yes, it is in the NGO updated geological assessment.
Yeah.
The figure's not actually, doesn't have a figure number, but it comes after figure 10. So you would.
It's kind of usually figure 11 because it sits
Yes.
between 10 and 12.
Yeah, that's correct. Yep.
That's fine. That's good.
Sure. So that shows the surface water channels on the upper terrace, and yeah, there's a channel that starts pretty much right beside the proposed discharge location.
And what was your? I remember the reference to it. So what was the concern about that?
Yeah, the concern is, I guess, that there's going to be very high levels of mounding, and that mounding could intercept that channel, and that could potentially cause direct surface water flow of contaminants before they've had a chance to attenuate towards No Name Creek.
That's the one just immediately to the west of the proposed discharge for the infiltration basin, correct?
Yeah, I think so. It's quite clear that there is a channel, and at least one channel is very close to the discharge location, and it heads directly to the head of No Name.
Yes. In fact, we looked at it on site.
Oh, okay.
Yeah. Yes.
I'm not sure how deep it is. So if it gets deep within the size deeply within the zone of mounding, then I guess that's a potential issue. But if it's very shallow, then maybe it's not a significant concern, but I'm unsure of that.
So there's another aspect about that because Cell D hasn't been completed, but that's actually not far from the discharge alignment, proposed discharge alignment for Cell D once it's constructed as well.
Yeah, right.
So that's what I was looking at, but anyway, those factors can be definitely taken into account. But it's not a deep incision; it's just moderate in terms of the contour that's in the area.
Yeah. So if we just go backwards, I think it's in my view, it's just important to highlight the quality of the discharge water. I kind of feel like that's really key. Up until recently, there was only one sample from a settlement pond, and we'd kind of been looking at samples from sort of leachate from the cells and such, and sort of assuming, because we didn't have much information, that we should use the most conservatively high value. So there has been another 4 or so, I think, samples now, maybe more than, I think 4 locations of a set of samples, which I think the applicant's saying is more characteristic of what the discharge water quality is.
And was that agreed in Culbertson that was a very bit to be part of baseline? Trent?
Yeah, absolutely, that we would get more information on that. Yep. But if you actually look at that later data, I feel like there's still not enough to fully characterize the source water quality. But if you do look at it, there is the indication, I think, that potentially contaminant concentrations aren't really considerably high. And I think that's a key issue. If that could be found to be the case and be reliable, then that's a significant thing to consider. And it also, I guess, if that is the case, then maybe even there's more potential for additional treatment because you don't have to treat it much further to reduce the quantities to something where you're not discharging anything over guideline values and such. So yeah, it's just something to consider, but I just don't feel like there's enough information for me to be really comfortable, I guess, that we've captured the worst case scenarios in the discharge water.
Yeah, I think that was being moved by us as well too.
Yep. And then going on, I still don't consider that we, I mean, it's the issue where I said, what's the potential contaminant concentrations at the nearest receptor? In my view, I don't think we still have an up-to-date modelling prediction, even though that's difficult because we kind of don't know the source concentration, but the modelling prediction to date is based on a receptor at 200 metres is my understanding. I think NGO might have indicated to me that they have done one at 100, but
I think that's the latest model.
Well, I think in the updated hydrogeological assessment, I'm pretty sure it indicates that it's still 200.
Oh,
so that's my understanding anyway.
So which that is, but I thought in the modelling revision that had been reduced to 100, but
that's been indicated to me, but I'm pretty sure I looked in the report. I could be wrong, but I'm pretty sure that I looked in the report to specifically check that. I think the input parameter in the model is 200 metres, the receptor.
Do you mind if I ask you a question now about the modelling?
Sure.
Did you hear my discussion with Ms. O'Rourke about the suitability of the risk model? What's your perspective on that?
I have had, I mean, I've sort of had some concerns with the modelling through the process. Some of those were to do with, or a lot of that was to do with kind of different iterations of the model getting different results all the time. I mean, generally, I think that my understanding was that the modelling now, I think we've probably got to that stage now where it doesn't include attenuation or degradation of the contaminants in the model, and I guess that's quite a conservative.
I saw that you suspected it was, or in fact it.
Yeah, I suspected it was, and I think that proved to be the case. And then the later simulations showed that suddenly we had detections of all parameters. But yeah, so I think it's.
But on the fundamental question, because that model will be used for further iterations based on new information coming in, so that the input parameters can be refined. But you're comfortable that it's a suitable model out of the suite of options that we know we have.
I think with where we're at the moment, I think it's probably the only way to come up with some consent conditions. I mean, basically all the model predictions are generally coming out showing that as long as that comes out and shows that at the nearest receptor, that the concentrations meet the guideline values and MAVs and such, then it's obviously providing us with acceptable predictions. And then, so you would expect that the concentrations then that it predicts at the nearest receptor, say, or nearest monitoring bore at 20 metres away, that's, I think, given where we're at now, that's probably the best that we've got. Although, in saying that, if we can also confirm that discharge water quality really isn't that bad, then maybe that negates, and we had limits even, like we could have limits on the consent saying that you can't discharge above this particular concentration, and if those concentrations are below MAV values and below ecological criteria.
Yeah, I mean, that was the tenet of Ms. Drummond's evidence too. I did ask her about that, and she said, well, her understanding was that provided that those receptor levels were met, then it was appropriate, so that there would be no, the effects would be acceptable. But the rationale was that you could back calculate off those levels, whether they're MAVs or whatever, and then back calculate to what the appropriate source concentration should be, so that the applicant can then manage that at source to try to ensure, and then you can achieve compliance at the discharge point. So that it all ties together. But you're comfortable, your expert opinion is that that's a suitable method to manage that.
I think it's the best method we've got at the moment. I think so for most parameters. I mean, it sounds like, because I'm actually not really familiar with risk 5 as well, and like our groundwater team doesn't use risk 5. And I guess my concern is that maybe
What they use?
we'll use ModFlow or we'll use Excel based like Bruce Hunt type equations and that as
Yeah.
well.
Okay.
Yeah. So
yeah, but I mean, can a numeric model like ModFlow be supported by the data, or would that have required even more?
potentially, although you can create a simple model just to simulate. Well, I mean, it's just another approximation of an analytical type solution in some ways, but being able to have a bit more complexity in the data. So yeah, so not trying to match heads and those sorts of things, obviously, but just to provide a general indication of.
But you could use ModPark MD3 and tack on to
Yeah.
achieve the same thing. Yeah. Okay, well, actually, that's really useful. You were just partway through your summary.
Well, I've pretty much finished my summary, really. The only other thing I've kind of noticed that's, I guess, come up. I mean, I've mentioned this issue before about the copper, lead, and zinc in the GDC supply and the treatment plant, and that was all a bit head scratching, I guess. And I mean, the applicant made a really good point that you know, the concentrations that were measured there were actually higher than any concentrations that have been measured on the site in discharge water. But there was just a feeling of, well, where has that come from? And I always thought it would have been best to actually take a sample from the bores directly. Is there some sort of process going on between the bore and the treatment plant that those metals have come into the system? And then
between an intake bore.
Yeah, there was just some results that we got from the treatment plant itself that showed elevated copper, lead, and zinc.
That's post-treatment.
Yeah, that's right. That's my understanding.
And that wouldn't be related to the disinfection byproduct situation that the upgrade has been driven for.
Yeah.
I mean, I'm not a specialist in that area, but I was kind of
Same.
interested in the fact that chlorine's become a problem for the applicant's site in the trials as well. Am I correct in that? So Mr. Stringer was saying that they've been achieved some positive results, but yeah. Anyway,
So I raised that. That is detailed in my evidence, but and the applicant did some work to look at relative concentrations of metals because there was some geochemistry sort of done looking at river chemistry, looking at and comparing that, and that did also potentially indicate that that water, that particular sample, had a different signature to most other things.
You've given me the perfect segue from my first question, which was you have commented on the relative contributions of groundwater to the water supply at Moorfield, haven't you?
Yes.
Can you expand on that a little bit? Not going into the chemistry, because I see where your assessment was coming from, but what do you think the relative contributions might be now?
Yeah, so that was a question, or that was something that came up kind of pretty early in the piece, where it was like, well, can we look at the performance of the GDC bores and sort of show that, you know, they yield very high amounts of water, they cause very little drawdown, and also I guess we did that geochemistry, and you could see that the treatment plant water and the river water, grey river water, was similar chemistry. So that was helpful because we did show that the new bore that's being drilled, BHO2, that yields really quite high. I think it's 70 odd litres per second. It only draws down by just over a metre. Yeah. So that's a good indication, I guess, that those river gravels are highly permeable.
What parents made the same point too. So that's a good outcome. But just in terms of what the relative contribution could be from source water emanating from the site.
Yeah, well, I mean, my overall thought and gut feel is, but it's a gut feel, I guess, because I haven't got anything to really back it up. But well, it seems most likely that, you know, any concentrations that get in the groundwater and then where that discharges. Generally, the groundwater groundwater flow is low, so discharges are relatively low. Concentrations are potentially, I think, relatively low. The pathway really there is into one of the most eastern culvert underneath there, and then into No Name Creek 2. And then it would be the risk, I guess, the theoretical risk is losses from that stream to the underlying gravels, intercepting the Holocene gravels, yes, and then intercepting the radius of influence of a pumping bore. And really, if they all perform like BHO2, then I think it's most likely that the dilution is massive, like it is huge.
Yeah, and that's why I was asking about proportionality. Yeah.
Yeah, but I guess I've noticed a couple of things, and in the drinking water safety plan, the GDC drinking water safety plan. There's some information in that. I guess there's a figure in there that shows the three bores, the three existing bores, and it shows water levels in those bores relative to river water levels. And it's quite clear that I think it's bore 2 and 3 show a very high response or a very rapid and large response to an increase in water level in the river. Bore 1 still shows that, but it's quite a lot less. And then there's also a comment in that report.
Is on that then. So that's a lower hydraulic connection with the Grey River.
Yes.
But what's the implication about that?
Well, the implication then is that bore likely performs poorer. It potentially may draw down more, and it may induce a higher gradient and it's more likely, I guess, if you're going to get into a zone of radius of influence of pumping from any contaminants, that bore might be more vulnerable.
Would you be to say how much wider?
I don't know.
That could be done. I mean, that's the analysis to do. But
yeah,
it's an interesting point, isn't it? So one of the bores could be more vulnerable to contamination than the other two.
Yeah, and there's a note in that report as well that nitrate in the supply water is actually higher than nitrate in the river. So that indicates a groundwater or a significant groundwater influence, I guess, in that not everything's being diluted by Grey River water.
Was this discussed in caucusing and included?
No,
that seemed to be an important aspect.
I've only noted. Well, actually, no, I did bring that up. I mentioned, I did mention those water level, the water level in the river versus the water level in the bores.
Yeah.
And I mean, NGO just said that, well, they hadn't seen that information, they couldn't comment.
Okay,
I think it's my
that's really
recollection.
interesting. Thank you. That's a take note of that. Now, just on another matter, going back to the infiltration, the capacity, and I think you mentioned that. Am I correct in saying 12 versus 300?
Yeah.
Now, this is less a question about performance of the infiltration and more about does it actually matter to us in terms of effects. Now, this might be more of a question for Mr. Durant to answer, and because I may have incorrectly taken up I did ask the applicant yesterday, well, look, what happens if you're so constrained in your exercise of consent that it's really just essentially not exercisable because the infiltration rate's so low, and I think your commentary here was, well, look, that is not an issue in regard to this consent, as long as the effects are established and managed through. Did I take that correctly?
If I can answer that now, I think there's it depends on the risk that is being taken, right? So to take a considerable risk to, say, potentially contaminate a water supply with a proposal that might not even be successful is a different thing, I think, to taking the same risk for for a proposal that's definitely going to work and prevent something else happening, for example, a pond overflow.
That's
Yeah.
why I was asking about it yesterday, but this probably gives a greater concern now because this is the first time I heard that it could be as low as 30. And that.
Oh, it's 12, but that is in my evidence as well.
Oh, right.
Yep.
Okay, sorry. Okay. What I hadn't appreciated that that's much lower than potentially could be operationally viable, but I don't know, that's for the applicant to sort out.
Well, yeah, if I can just add that, I think if the proposal works or doesn't, that's a risk for the applicant to take.
Yeah, okay.
But if granting the consent poses a risk of an environmental effect and it won't work, then that's it is incumbent on the decision maker then to consider that.
Yeah, it wasn't a combination, so all.
Yep.
Yeah.
I've basically done the same calculations, although I've used Bruce Hunt's mounding model, but it gives very similar results to the Hantush model. But I guess where it differs is I use the hydraulic conductivity from MB13, and that's the lowest hydraulic conductivity derived from the slug testing.
Do you think that's representative?
Well, I think it's the best that we've got because it's the one that's right next to the discharge water.
Yeah.
So, yeah. I think slug testing is never ideal, and like the best case you would do a pump test, but then I think a pump test probably would have been quite hard to do in strata that's so impermeable as well. But you'll get a wider average of hydraulic conductivity from a pump test than you will from slug test. You're more just directly around the bore, but being directly around the bore, I feel like it's probably the most, based on the information we've got, it's probably the most appropriate value to use. And I also used the specific yield of 0.1, which I know NGO have recently used 0.25, and that seems potentially too high to me.
I think the Queen's considered 0.25, but anyway, that's
sure.
Judge. Hey, look, if I can just go to a last couple of questions from your evidence, and this relates to what is your final position on the potential for fracture flow? Yeah, I want to sort of be clear about what we need to consider for decision making.
Yeah, my final, I guess where I'm at now is, I mean, I can state that, again, my gut feel based on just looking at the conceptual hydrogeology and geology is that it's unlikely that there will be a significant flow pathway. But I feel that given the potential consequences, I guess, in this case, and the fact that there is a public water supply that serves 10,000 people, I'm not happy with just accepting that that risk is low and relying on information. I think one of my biggest problems there is the information that has been provided has been from sites that are sort of 50 kilometres away or such, and also assumptions that were made about swelling clays and such early on in the piece. And then when we actually did some analysis and looked at the potential clay content in the Kayara mudstone from a site much further away, it actually didn't necessarily indicate that you had clays that were particularly highly swelling as well. So just stuff like that. I mean, I feel like, yeah, data on site was what would have satisfied.
This is my very last question for you.
Sure.
How would we gain a sufficient understanding to reduce the uncertainty?
Well, it is difficult. So I'll admit that, because you can miss fractures. But I mean, if you miss fractures, that tells you something in itself. But I feel like, I don't know if there's any outcrops on site as well. And there's obviously mudstone outcropping in the road cutting. So some sort of actual geological assessment of that and viewing fractures and such.
Your opinion that this is an area that does need greater investigation.
My view is that it does, because of the consequences. And I wouldn't want to, I can't make a decision and then or based on an assumption, and then I'd hate to find out later that I was wrong.
Yeah, well, I mean, we've talked about consequences.
Everybody feels that way. Yeah.
Okay, well, yeah, thank you. because that's
Sorry, just check if anything that
My water.
No.
It's not too bad.
Positions.
Oh, yeah.
Catching.
Cheers. There's not much. Thanks, Tim.
thank you very much.
Thank you.
What it says, firstly, I just kind of want to acknowledge that I was obviously not the person who submitted and wrote the evidence. So, and there's been a few updates and I think involvements in both the applicant psychologist kind of opinion and our own opinion as we've kind of travelled through time since that original submission. So I'm presenting oral evidence today based on that originally formed by the written evidence by my former colleague, Duncan Gray, but I did review his evidence prior to submission and I was in agreement with it.
You won't be full thing, but do you adopt that evidence basically?
Yes, in the most part, but the evidence, that written evidence, would have changed somewhat based on more up-to-date information that's been provided and including the assessment of values from Ms. Drummond.
Will that be reflected in the joint witness statement?
Yes, some aspects, but again, I guess over today and yesterday, there's been new things that have come to light as well, which I kind of want to touch on as well. Yeah. So, yeah, I think I probably covered that off. So I think, you know, during that joint witness statement, myself and Ms. Drummond were in general agreement about the waterway values. She kind of acknowledged that post seeing the evidence of Dr. Gray, that those values were reviewed. They were originally assessed as of low value, but have since been kind of upgraded as a moderate value using that IANS criteria that Ms. Drummond adopted. Also just want to note that I have been to site since the joint witness statement and sort of that formation of evidence. I'd like to go just into a wee bit more a wee bit more detail and just recap the waterway values issue. So the applicant psychologist and myself are in general agreement that stream values through and adjacent to the TRP site are moderate, an exception being the roadside drains, which you know generally have negligible values, but you know they are important conveyors of leachate contaminants to surface water bodies. Something that's come up repeatedly over the last couple of days is Unnamed Creek 2. That flows in a position that's kind of south and southwest to the proposed discharge site. And it's kind of been suggested through mounding underneath the discharge site that it's predicted that there'll be more radial groundwater flow and contaminant flow, so that there might be a pathway for contaminants via groundwater to the north, to the head of No Name Creek, but also to the south and into Unnamed Creek number 2. To date, Unnamed Creek number 2 has not been assessed in regards to values. During my site visit, Mr. Singer kind of accompanied me around the site. I did have a quick look at Unnamed Creek 2. And there's no reason for me to believe that those values wouldn't be akin to what's been seen in No Name Creek. The habitat was very, very similar. There are issues around fish barriers and things like that, which I don't think anyone truly understands. But I think moderates, at this point in time, I couldn't see it being either way. I think moderate's probably a fair call just for the purpose of this discussion.
A similar stream.
A similar stream from the short reach that I observed. It had, cobbled beds, some moderate flows, good flows. It was a reasonably narrow channel. It did have varying degrees of riparian vegetation and that sort of thing, but in terms of the fish species and the macroinvertebrate species that you'd expect to see there, the habitat's kind of conducive to support similar ones as similar macroinvertebrate species because of the habitat, and a fish passage was not an issue in either stream, and it would support similar fish communities. On that note, I think the assessments that were done in terms of fish communities in No Name Creek were potentially underestimated. The reasons being, and I think you touched on this yesterday with Ms. Drummond, that it was a very rapid assessment. It was an overnight. A couple of traps were put out, and to be fair, to properly quantify those values, you'd be out there with a torch if it was safe enough, or do some electric fishing of those water bodies.
So significantly underassessed, or just?
I don't think it would have necessarily any material difference to qualifying a moderate overall value. But in terms of the actual fish species present, then potentially, because No Name Creek, there were no fish found, but it's entirely possible there could be eels, lamprey, coardo. These are all species that are very apt climbers, and the likes of coardo can climb up waterfalls, and lamprey can too.
The various situations under Taylorville Road was identified as a potential issue for those fish, climbing fish that they refer to.
I think, yeah. There could be a potential issue, and I would have liked to have looked at that in a bit more detail, but you get to site and it's very overgrown, very steep, and it just wouldn't have been safe to access. And I think, from my understanding, Ms. Drummond accessed them as well as she could. We looked at photographs in the joint witness statement process, and there was no formal assessment made. So I think if there's perched pipes, then that would be an issue. But if it's just a question of steepness of the catchment, or kind of little waterfall drops and that sort of thing, then it's entirely possible fish can get up there. Yeah.
Okay, what's a perched pipe?
A pipe that sticks out, basically. Yeah. Ms. Drummond's assessments of aquatic invertebrate communities was sufficient and adequate. I think those picnic samples, characterise No Name Creek as having, good rain, low diversity, but the presence of pollution-sensitive species, so that's like your mayflies. And then the macroinvertebrates that were found in grey tributaries were probably more driven by the fact that there's a lot of sediment, fine sediment, which smothers the habitat on the stream bed, more often than like a water quality issue. Some of the water quality information that's been presented to date by the applicant indicates that water quality in No Name Creek is, moderate or high quality, notwithstanding, some nitrate values and that sort of thing in there. But testing to date has found some evidence that there's potentially leachate getting into the grey tributary just from, there's evidence of sulfates of higher concentrations not as you move down, because there's greater dilution, but at below, as I think where No Name Creek, where the culvert feeds in from those roadside drains.
Ammoniacal, so just on that point, nitrogen leachate associated nitrogen species are going to potentially be discernible from agricultural nitrate.
In my experience, not necessarily. You often see if you're having high concentrations of ammonia or ammoniacal nitrogen coming out close to a source, then it's indication of something like a leachate. But
I was thinking more of the reverse, actually, that could well be contributions from the broader catchment.
Oh, yes. And I think sampling of that receiving environment has indicated that, it is, there's certainly background concentrations there. That's not owing to the landfill operation from agricultural inputs. And I guess just related to values, I just want to acknowledge the importance of protecting the mode of all water bodies as mentioned in the submission of Ngāti Waiwai. In regards to potential and actual effects, it's been cited by the applicant that ammoniacal nitrogen and arsenic appear, or are mentioned repeatedly as the primary contaminants of concern. However, on the limited information that's kind of been repeatedly cited, or the hydrogeologists like Mr. Stephens and Ms. O'Rourke have sort of cited concerns around the extent of information on the discharge quality. And there is presence, although a lot of the time only just over sort of what you'd expect to receive in waterways standards of, like manganese, chromium and zinc. So, just want to acknowledge that they are there in elevated concentrations to a certain degree as well.
Are they associated with farming activities as well? And
I have seen zinc in agricultural waterways before because of historic farming practices. It's going probably a bit beyond the realm of my expertise to comment too much further on manganese and chromium and that sort of thing. So I just want to wish to highlight that, all those contaminants in question can contribute to toxic impacts on aquatic biota. The guidance of the Australian and New Zealand guidelines for freshwater and marine water quality, they contain standards for toxicants, and that's been used by the applicant repeatedly. A lot of the time they pertain to chronic effects, so that being long-term repeated exposure effects rather than short-term effects. However, I consider that appropriate for something like a 6-month duration. We're not talking about something that's kind of sustained. In the context of the receiving environments, the 95th percentile level of protection that's been used from those guidelines, I consider those to be appropriate for the most part. And that's been agreed to date. However, I should note that more stringent guidance is generally recommended for PFAS contaminants, and that's because the guidance that's out there.
If you see a titanium walking pole, are you going up to the skid site? Oh, okay. Oh well, if you see a pole, I've gone walking and I've placed it somewhere and I've.
You might want to mute yourself, Anthony.
oh, that's really.
So, picking up where I left off.
That's it. Not so.
So the 95th percentile species protection level is appropriate for slightly to moderately disturbed ecosystems. However, the most up-to-date guidance recommends a 99% threshold for PFAS contaminants, and that's due to the potential bioaccumulation of those contaminants in the tissues of aquatic animals, essentially, and the ability for that to cycle and accumulate through food chains. And that's actually of importance, or it may or may not be of importance, but if anyone's collecting, say, mahanga kai or any sort of food from these water bodies at direct kind of proximity to the landfill, it should be considered, because that's a human health issue as well. If there's any sort of consumption of
So does that imply that for the other contaminants, it's possible to manage at the 95%.
Through you'd imagine that everything's going to move up to a more 90 in terms of actual management of a discharge, or are the effects different? And you could, for the other exposed species, you could manage it at the 95%.
Yes, yeah. So if I'm understanding your question correctly, 99% would be for those PFAS contaminants, whereas you'd manage the 95th percentile for the heavy metals and so forth.
Yeah.
Yes, yeah, because the effects are different.
Yeah.
So 99% for PFAS. Is that agreed in the terms of wider community contribution?
So I guess like a lot of things with PFAS contaminants is it's kind of a developing field. I note that I can't remember the document that was referenced, but Mr. Griffiths used it for forming his original opinion of using screening at the 95th percentile, for ecological reasons, for conditions, for discharge. But that document takes the guidance of the Australia, New Zealand water quality guidelines that usually get used. And both of those documents cite that 99% should be used for PFAS contaminants, and that's the best available knowledge that we have to date. Another side note, I guess, on acceptable standards is the applicant's evidence to date has, yes, 95th percentile standards for toxicants are generally appropriate, but I haven't seen any sort of reference to national policy statement for freshwater management attribute bands, because the national bottom line in table 5, I believe, for total ammoniacal nitrogen is much more stringent than that 95th percentile protection limit. So I think it's been cited at 0.9 milligrams per litre. And, the modelling is always sort of aiming to reach that as a bit of a target for receiving environments, whereas the NPSFM cites a more stringent value in that respect. And that would be what I would consider to be a more appropriate value.
Oh, would you?
Yeah. That is subject to planning and legal interpretation as well in terms of what's appropriate, I guess.
Is that becoming more common in systems, the use of the bottom line? No?
Yes. In my experience, you tend to refer to both, but national bottom lines are kind of, I guess, a line in the sand in terms of maintaining, improving, or protecting water quality. I think coming to the end here, I guess touching on monitoring is, a lot of the discussions over the last couple of days have been about, okay, if a consent's granted, some of the effects will be managed through, say, the discharge monitoring plan, or it might have evolved into another title now. From what I've seen from the draft to date, there's no reference to any surface water quality monitoring. It's all focused on groundwater monitoring. Whether surface water monitoring is appropriate for managing effects is a question I want to raise, because from my understanding from the hydrogeologists is that if the discharge to land occurs for 6 months, then it might not be realised any sort of contaminants in surface waters for a period of years. So, for any consent, if you're monitoring, it's got to inform something and have a purpose. But yeah, any effects to surface water might not be realised until after a discharge is finished. So therefore, considerations, if surface water monitoring was part of the discharge monitoring plan, there should be considerations that monitoring should continue, I guess, beyond the discharge activity itself.
That could be for a number of years, you suggesting.
Potentially, but yeah, I mean, there's information that would need to be firmed up from the hydrogeologists in terms of when that would be expected in receiving water body, and then for how long would it be expected that any sort of potential plume might pass.
That issue could be considered in a second. So make sure that it's accommodated.
Yeah, I believe.
Responsibility.
I believe so. Yes.
So just on that, and this is my only question related to the JWS for you. It appears, and this is not unique in the witness statements, is that it's all subject to the hydrologist's reconfirmation of actual likely discharge concentration, and then these assessments are subject to that. So would you envisage it would be a review of this position at that point? How do you conceive this working? Because that's got quite a bit, all these assessments are largely agreed, but there are quite a big caveat on them. Relates to what the hydrologists and the contaminated land experts are going to drive for discharge concentrations.
Yeah, essentially. I mean, my level of certainty is always going to be commensurate with the hydrogeologist's level of certainty, so it's almost going to run in parallel. And I mean, that was going to be the basis of my conclusion, is essentially, just need to search for more confidence in what's going to happen to those contaminants in terms of pathways and concentrations and the quality of the discharge, to have confidence in that model and then really firmly say whether the effects are.
Do you hear Ms. Drummond's response when I asked her the same thing yesterday? And it related to how she was framing her evidence, and she said, well, actually, it doesn't really matter because these receiving water criteria are absolutes based on those assessments, and so therefore the discharge concentrations have to meet them. And that's the way she framed. That was my understanding of how she responded to it. And so, you're setting 95% level, you're setting all the criteria for this. She said it doesn't rely on any dilution, any mixing is not required. These are point discharges, so therefore they just must meet them. And so therefore this assessment stands on its own. Do you not agree with that?
I mean, to a certain degree, again, and I might be getting this wrong, but from what I've seen of the hydrogeology assessments to date, they have almost conservatively assumed no mixing. But I think, that could be built into a component of that in terms of.
But conservatively, it doesn't need reasonable mixing at all at the moment, which is good.
No.
It gives you a low factor of safety, which she confirmed. But
yes,
it was really just sort of reversing the situation to say, well, this is what it must meet. So therefore, the discharge will either impact on that criterion or it won't.
Yes. Yeah, and that's a fair statement, and it's just ensuring that all those triggers or receiving water standards are appropriate and fit for purpose.
That's my question, and you think that they
are? I mean, subject to what I've just mentioned about the national policy statement and PFAS, so there is some revision and revisiting needed.
Okay. Thank you.
That's it. Thank you.
Can I suggest that there is some question around the wetlands that are acknowledged in the joint witness statement?
Oh, there was.
And whether it would be useful for Mr. Arthur just to comment on those a bit.
Yes.
Yes, apologies, actually, I did write down something, skim past it. So, yes, I mean, there's been no assessment on wetlands to date. And I just want to clarify that this is not primarily my area of expertise, but on my site visit the other day with Mr. Singer, it was clear that there are wetlands associated around the banks of the Great Tributary, and Ms. Drummond mentioned that as well for the joint witness statement. it'd be important to look at those and the implications of that in the face of, this application. From first look, there was some native species, vegetation species in that, and there was a lot of exotic species as well. So I can't comment further because it is beyond my area of specialty, but generally speaking, it needs to be considered in an application like this.
So there, noted as environmentally significant stuff. Goes through the process statement. That's the ones we're talking about.
Yes. Yeah.
And Janie Rees reports that you robustly assess what the evidence notes that, well, the Janie Rees notes that they are identified as technologically significant.
Yes, so that was Ms. Drummond's conclusion, which I support.
Associated mainly with the floodplain of the Great River and the.
I wouldn't exclude that as potential presence elsewhere, but that was where I and Ms. Drummond have witnessed them. That's not to rule out other areas.
All right, thank you. Something.
Jerome was just asking about a particular area that I don't have confidence over, so I can't make a statement on it.
I can make a statement on it, it's okay.
Yeah.
Okay.
Thank
you. Yeah, to make sure I ask a question, has your regulation changed?
No. No, but I can take you through how.
Yeah.
I thought it'd be helpful, if this is all right, to talk about three main elements. One is the outcome from the expert caucusing. There's just a couple of things I think are important to take you through with that, or just to highlight in the JWS.
And you're happy for us to question as you go?
Absolutely. So the expert caucusing outcome is the first one. The second one is to point out a few things about how I think the planning framework applies. Just think from the discussion over the last couple of days, it might be helpful to maybe explain it in a slightly different way than the sort of standard framework that I went through in the 40-slide report. The third point is around how sufficient the application is in dealing with the matters that arise through the planning framework. And that's been canvassed quite a bit, I think, in relation to the types of information that would be needed and whether they're in front of you or not. And the fourth thing is just came up just now, which is this possible vicinity of wetlands in relation to the location of the discharge. But I'll only speak to that briefly, I think. But so if that's all right, if I just plough through those and then you can ask me as you go. So I don't know if you've seen the joint witness statement. Carl Cook and I discussed a few things, but most relevantly, we talked about the relevant statutory documents, and we agreed on which are relevant, and we agreed on the interpretation of them. We didn't discuss the Water Services Act, and I'm going to talk about that just slightly. It's possibly not a planning document, but it does. I think it does relate, and I might be able to helpfully add something useful there. The conditions and term of the consent, we discussed that too. And we didn't discuss wording of conditions, but we discussed like conceptually what conditions would need to cover and how they might be developed. And we agreed on that too, but I do have a caveat to add to that, which I'll come to in a second. And that included the duration of the consent as well. Mr. Arthur just mentioned before about this idea of a relatively short-term discharge, but the consent granted might require monitoring to occur for a period of time with a long tail on it, because it might be several years before a signal appears in groundwater in a particular location. So we discussed and agreed on that as well. accepting that the term of the consent sought is 6 months, but I think we considered that on our understanding of the evidence, it might be better to grant a consent that provides for a 6-month discharge, but the consent remains live for a longer period and requires monitoring over that time.
That's not unusual.
No, I wouldn't have thought so. No. And there's nothing, you could draft a condition that provides for a constraint around the timing of the discharge whilst living on beyond that. That'd be relatively simple to do. It's probably not typical, but it's easy enough to do. And we also discussed the matter of alternatives, and there's an element of that which we didn't quite agree on, but I'll come to that. Too. So I wanted to clarify, there's a statement made in paragraph 6.2.2 of the joint witness statement. And that relates to best available information. And I think that it was discussed earlier on by the submitters about the National Policy Statement for Freshwater. So that includes a clause saying the council has to act on the best available information, and the council can't delay processes in order to achieve kind of perfect information. Decisions have to be made on the information available at the time. Now, we agreed, if you don't mind if I can read it out, we agreed that in the context of the application and supporting information and evidence, this can be addressed, as in the information before you can be addressed through the exercise of the consent. And it's a brackets, e.g. by a consent condition on the discharge involving monitoring trigger values or limits and actions to be taken. But that had a caveat on it which said, provided that the information collected during the exercise of consent can be acted on to avoid, remedy or mitigate adverse effects. Now, I think at the time that was agreed, certainly for me, I didn't appreciate the time it might take for an effect to occur, for example, in the water supply. If you like that, from what I've understood from the other experts, it could be several months or maybe years before an effect might arise, if it were to arise, by which time it's far too late. The discharge will have ceased by then. So the action that could be taken is like no action could be taken short of no action to cease the discharge anyway, to do something else with the groundwater or treatment or something. So I wanted to kind of add a bit of colour to that, so the can be acted on clause. I think it would require, if a discharge were to occur, there'd need to be, with a condition that required monitoring and with a trigger and an action, the monitoring would need to occur so close to the discharge point that you could effectively cease the discharge and avoid the effect. Yeah, so the monitoring would have to occur very close. But how close, that takes some expert input on that.
But typically, in thinking about how like water responded to, you really need that and something that's going to give you even more early.
Well, yeah.
Because almost if you find it near the well, that's too late.
Absolutely. Well, I'll come to a possible remedy for that situation in a moment. But I mean, like we heard from Grey District in their submission, I think it was 6 hours of water supply storage that they have for the town. So they basically have no alternative supply, no contingency. So it's not like a lever can be pulled and an alternate supply provided. But I've noted as well the submissions from Grey District and from Ms. Bezier, who was speaking for Mr. Van Dort and Ms. Mertens, about the Environment Court's guidance on conditions, that they shouldn't be used for, they didn't use these words, but if you like, for research purposes, to provide information to justify a consent decision after the fact. They need to be, the consent conditions, monitoring is to demonstrate compliance with the consent, should be for that purpose, rather than to investigate and gather information and then modify a proposal after the fact. So I'm cognizant of that too. That if you like, that tempers that statement that we agreed to in the joint witness statement for me anyway, that the scope of those conditions, it's talked about in kind of general terms around that a consent condition could be used to gather information that information has to be, in my view now, to demonstrate compliance with a consent that's been granted, rather than to collect information about how the groundwater is behaving, how contaminants are attenuating in groundwater, or those sorts of elements.
What's proposed to establish a baseline?
I think that would have to be work that is done prior to granting the consent.
Yes.
Yeah. Now, I think that it's possible that's what the applicant is going to propose. I'm not sure, but I don't think there's a formal change to the proposal in front of us at the moment. But that would be my view. Yeah, that a consent shouldn't be granted with, if you like, an adaptive management and a suite of investigative work to be done, and then decisions to be made or actions to be taken subsequently to that. That work all needs to be done up front. I think maybe in some circumstances it could be justifiable to have adaptive management conditions, but like we've heard from a number of people, in this case we've got probably the highest risk receptor there is in close vicinity, even if the risk of it being contaminated is relatively low probability. Still not the type of receptor where you want to, where in my view it's not appropriate to defer assessments to a future date while the discharge is happening.
Right. So from a planning perspective, how does adaptive management work when you're planning?
I've worked on a couple of consents that have adaptive management. My understanding of them is that the consent allows an activity to occur, and then it requires monitoring of some description to be undertaken, say an array of monitoring bores. Say it's a discharge that gets into groundwater. You have an array of monitoring locations. There's monitoring at an agreed frequency for agreed parameters with, you'd have probably a sequence of levels. You might have a alert level and maybe a action level and a limit, say, but the levels that are detected through the monitoring compel the applicant to do something, either to carry on with the status quo or to reduce their discharge or to treat the discharge or to cease it or something like that. The versions that I've seen most familiar with related to groundwater nitrate concentrations in dairy situations, where the nitrate, depending on the amount of nitrate that was picked up, there's a destocking exercise that might occur to reduce the footprint of urea from the cows. That's the situation I'm familiar with. It only works, from my understanding, when you have essentially an isolated system. If you've got inputs if you've got contaminant inputs from other sources, it's hard to with certainty point to the monitored value and say there's a change in this value we're observing over time is because of this activity that's occurring under the consent. If you've got other inputs, it's difficult to isolate them, and it's easy for consent holders to argue that it's not them, it's somebody else that's causing this. So it depends. I think possibly in this case, depending on the location of the monitoring, so again, don't want to talk out of turn as not a technical expert, but I think it seems feasible that monitoring in some locations for, say, novel contaminants such as PFAS, you could monitor for that and be quite confident it's only coming from this discharge as opposed to some other source. Depends where the monitoring is located, where the monitoring is undertaken. If it was on the site, it's probably a different story to, say, in the water in the river, because there's a whole catchment above where various contaminants could be sourced.
Do you think it might be confounding, though, that there are 2 or 3 other similar activities going on in the area, though? That could, there's very unique contamination, but there could be contaminants that could well be attributable elsewhere too.
I mean, you asked, I think it was you asked Mr. Cook about the relevance of the vicinity of the other landfills about 1 kilometre to the north. I think it seems unlikely that there would be material on the Taylorville site that's arrived there from that landfill to the north. So if you're monitoring for PFAS on the site, say, in the groundwater on the Taylorville site, it seems not.
Actually, when thinking the landfill, I was thinking of the disposal area that's been developed
Directly across the road, just to the south of Taylorville.
The disposal area.
Yeah, it's just it's an ex-quarry
Just with the
downstream.
discussions with Mr. Stringham, I don't know the details of it at all, but he was pointing across to it,
Oh, that one.
and he said that's been developed. Anyway, look, not to divert, but it may not be that as fully straightforward either.
That's right. Now, the example that I worked on was actually in Mackenzie, where there was dry land farming all around, and then just this one dairy farm, which was basically the only source of nitrate, of considerable nitrate in the whole area. So it was relatively easy to say, what we're picking up here is because of this activity. Yeah, so that's what made an adaptive management approach, I suppose, reliable in that sort of situation. Here, it would have to be done quite carefully to make sure those other sources, if they exist.
So you're not saying counter, it just has to be done here.
Yes, yeah, I think so. And I'd have to rely on technical expertise to understand that. But I think the design of it and the data that inputs into determining the limits and the actions need to be established through this process, not after the consent is granted. And that's for the reasons that were earlier on raised by Grey District and others about the Environment Court guidance on consent conditions, and because of the level of risk, because of the matter that Carl Cook and I agreed on, which is that you have to be able to effectively act on what you find from monitoring to prevent whatever it is you're trying to prevent. So meaningful action has to be taken to avoid effects if that's the purpose of the monitoring. Do you have any more questions on that, or shall I carry on? The other matter I wanted to talk about is the planning framework and some of the thresholds that apply. So the first question, I pitched this in terms of questions that would need to be answered through this process, and the first one is around whether the drinking water will remain safe. And I use the word safe because that's the word in the Water Services Act. And there's a clause there that says water suppliers have to ensure that drinking water is safe. Yep. So there's a definition in the Water Services Act of what safe water is. And that is water is safe if it meets the drinking water standards. Now, I think Mr. Perrin-Smith said something slightly different. I'm talking about what I read in the legislation.
Yeah, that's the reason we explored that, because in terms of water management, there are other thresholds that need to be considered.
And I'll come on to some of that.
Yeah.
But if you're looking in isolation at whether water is safe, it has to meet the drinking water standards and stay within those boundaries. Safe under the Water Services Act, if it remains that way. Now, those same standards apply to the NES for sources of human drinking water. And that says that you must not grant the consent if doing so would make water that is currently safe, it would make it unsafe. Yeah. So that applies, and it's the only case, from what I can tell, Carl Cook and I agreed on this. It's the only part of the planning framework that provides, if you like a knockout punch, where it says you have to make this decision. You must decline the consent if that is likely to happen. So if the drinking water is currently safe and it's likely to be made unsafe, I think there was a bit of discussion about what does likely mean. It's not clear whether it's 51% or some higher. But that's the only part of the planning framework where it says you must make this decision. So do not pass go type provision. If the water will be made unsafe by the granting of the consent, then you can't grant it. The other provisions there's one that's about avoiding effects. It says this is policy 3.3.1. It doesn't say effects must be avoided. It says the priority must be given to avoiding effects. It doesn't mean that an effect shall not occur. I mean, the directive is that the decision makers think about it in a particular way by giving priority to this outcome rather than you must achieve that outcome.
Or is that just a reflection of that plan, which appears to a lot of provisions repeats
Or avoid, remedy, and mitigate, yeah. I mean, it adds a little bit more colour than that because it says give priority to avoiding. Yeah, I mean, some plans do that, right? They just say it's a discretionary activity and the policy is to avoid, remedy, or mitigate. It doesn't take you very far. This one does more than that by saying it's a priority to avoid these effects. And that was partly why I landed on the recommendation to decline the consent, because I didn't consider the proposal as it stands gives priority to that outcome, or you couldn't be seen to be giving priority to that outcome by granting consent where there are considerable uncertainties as to what the contaminants are in the pond water, where they're going to go in the environment, whether they'll be attenuated or not, and what the effect might be. That's why I landed there. If you don't
policy, that policy was a big influence on your recommendation.
Yeah. Yes. Yeah. And part of the a relevant further part in that assessment is the definition of effect. Now that's been raised by other people too, and that includes, and there's a particular word here that I think is important. It includes any potential effect of low probability which has a high potential impact, and it's the word impact that I think is particularly interesting because it doesn't suggest that it's something different to it's not a high effect. It's something that has a high impact. So, and that made me consider, well, to what extent is an impact related to, say, safety of drinking water? Would you say that it's a question for you to answer? Is it possible that a contamination of a water supply, for example, could have a high impact and yet the water remains safe? So a discharge contaminates a water source, and water quality for the 10,000 people who use that water is changed. The impact on that community could be quite much from the knowledge that that water is now contaminated, even though it remains within safe limits. Now, it's a question to judgment as to whether a high impact and or unsafe water are the same thing, or whether they are different things and need to be considered separately.
Perception basically is an impact.
Well, I think that is relevant. Yeah. But it steps out from a lot of what we've heard is around sort of technical assessment of where does a discharge sit in relation to a standard, and is a standard going to be exceeded or not, and health-based standards and all those sorts of things. But
in terms of that, there was a more real consequence, and this is what I was doing with Mr. Perry Smith, and that relates to detections well below.
That's right.
And that is the definition in the Act, absolutely. But prior to that, there's a whole number of regulatory responses that happen well ahead of that. So they're not only about perception, they're about real impacts on supply, which could limit supply. They might have to look at alternatives before. So
so the other relevant part of this is policy 3.3.1, the water and land plan, which is to prioritize avoiding adverse effects. So the policy doesn't say you should avoid contaminating source water beyond health limits. It says you should avoid effects. So that, to me, there must, I guess it's possible for a change in water quality, source water quality to occur. But to me, avoiding an effect is somewhat lower threshold than if it were to say you should prioritize keeping source water within health limits. It doesn't say that. It's something much tighter than that. So I think it doesn't tell you the whole story. So look at the Water Services Act and look at the NES for drinking water sources and say, well, the water will still be safe according to those standards. You could still, the consent that allows for that could still be contrary to the regional plan, which requires you to prioritize avoiding effects.
A very high threshold on applicants from then, isn't it?
Yeah.
If the standards are met, you're saying that still be an obligation to avoid effects.
I think so, yeah. Because those effects, even if they are low in relation, like it's only a small change to the contaminant concentrations that are managed by a standard, the impact of it on the community could still be quite marked, depending on what it is. But for example, say it was PFAS, that even if that the community's understanding of it isn't complete, or even if the actual threat to their health is low, that could still have an impact that's quite marked. I think that is somewhat speculative, I suppose. There's no evidence on that, but
Because if you take that to the extreme, then fluoridation of drinking water would be an impact on a part of the community, who vigorously oppose it, think that it's evil. So if you that's taken to an extreme, as I say, but that's what the consequence of that interpretation could lead to.
that's possible, but that would only occur by going through a public process. So you do it on an informed basis.
Go through now.
This is a public process. Like through, I mean, the public would have a chance to participate in that process. The public, this is public in that it's visible to the public that they aren't participating in it. The application wasn't publicly notified.
I'll mention some more on that.
Yeah.
Issue.
I'm not that familiar with fluoridation of water supplies, but I suppose there's
Just using it as an example, because if it's just because people don't like it, even though the water is safe and meets all the standards, that would be a very potentially have a very significant impact on development.
The difference, I suppose, is that there's some people might not believe it, but there's a health reason for doing it. There's a public health reason for doing that, whereas there isn't a public health reason for this discharge. Not in the same way, anyway. Not a community health. Yeah. So different. That contamination of the water supply by fluoridation would be occurring in a different context to what we have here.
Well, it's just an example. But just look at the consequences of that interpretation. Because it seems to me that if you're saying that, you take it to the extreme, if members of the community are offended by something, then that needs to be avoided. Even if it's permitted at all.
Yeah, in an ideal world, you do it on some evidence, right? But
That's interesting, but I'm just exploring with that.
But I don't think that it means avoid contaminating source water drinking supplies beyond health limits. If it meant that, it would say that. No, but it doesn't say that. It says to avoid effects. Yeah. Yeah, especially since I'm not sure about the timing of the NES protection of drinking water supplies. I think has been with us for a while now, 2005 or 6.
Yeah, it's been needed very recently.
Yeah, the Water and Land Plan postdates that. So if it meant to sort of transpose the NES's provisions into a policy around how to protect drinking water supplies, and with the same intent, maybe they should have used the same wording as is in the NES, but didn't do that. It said to avoid effects. Yeah. Yeah, so I don't know if that's helpful, but I thought it's there's these different thresholds that are in play within the framework.
Yeah, and it does look back to very early discussions and legal submissions, so that might fit.
Yeah. Thanks. The other thing I wanted to cover there that is also related to section 104G, which my understanding is that was introduced as a follow-up to the Havelock North inquiry results, and I wrote a bit about that in the 42A report as well, because those principles that came out of that were quite helpful. And that talks about, so 104G, the wording is about the source of a drinking water supply. It's not the supply itself, it's about the source water. Yeah, so it's not, it says any risk, you have to have regard to any risks of the proposed activity, may pose to the source of a drinking water supply. So that seems to refer to whatever the source area is. Now, if you look at the guidance from MFE on that, there's Source Protection Zone 1, which is right in the vicinity of intake bores, the Source Protection Zone 2, which is somewhat wider, where water may contribute to Source Zone 1, and then you've got like the bulk of the rest of the catchment. So what exactly it's referring to there as the source of drinking water, I'm not sure, but it's I guess that to my mind, that's what the debate is here at the moment, as to whether this discharge is inside or will flow to become inside the source zone for this drinking water
How
supply.
that's typically defined as with a catchment risk assessment, that is a prior step to a source water risk management plan, and that appeared to be indistinct. And it addresses the particular issue you raised there. So who's in and outside those particular zones that you're describing? So the steps are that you establish the drinking water safety plan, you then go with a catchment risk assessment to establish those boundaries in those zones, and then you establish what management is required inside of those zones specifically.
Yes.
Under the source water risk management plan. So there's a logical sequence to it. So your point is exactly right, but I think the definition, to my read of it, was not there.
Source water.
The three zones that are required under source risk management planning within this drinking water safety plan.
Yeah, that's my understanding too.
Yeah. So that would have given the definition.
Yeah. There's two other matters that I wanted to cover. One is, I'm not sure how much appetite there is, but for the question of alternatives, because I made some statements about that in the 42-hour report. And the other thing is around the quality of the discharge itself, which I think has also been called source water during these, as in the source of the discharge rather than the source of. So I said in the 42-hour report that I thought that the applicant's assessment of alternatives was deficient, and Carl Cook and I didn't quite agree in the joint witness conferencing about that. So I made a statement.
Paragraph is that
11 in the JWS.
yes.
All right, and you reported that you didn't provide a consistent or functional alternative.
Yeah.
We'll speak to that.
The reason I think that's important is because this is the part Carl Cook didn't quite agree on this, but to my mind, there's if a risk is to be taken by granting a consent, then it's helpful to know whether that risk really needs to be taken or not. And that's where the alternatives assessment comes in. So if there is an alternative that can readily be pursued instead that avoids that risk, then to my mind, that's a preferable, all other things being equal, that's a preferable decision to make. Now, I know your job is to make a decision on the applications in front of you, and that's somewhat binary, and that you can really only say yes or no. But my point was that the applicant, in my mind, should have presented quite a fulsome assessment of alternatives to show exactly why lower risk options aren't actually, aren't possible, or certainly aren't the best practicable option. There's a cascade there, a cascade of assessment I think you'd go through, where you start with everything's possible, and the Act does say that. It says that a description should be provided of possible alternatives. And I think there's again, I'm not a lawyer, but there's a case, the Transpower case in Tonga talks about this, where the applicant didn't look at what was possible, they just looked at what they thought wasn't feasible. there's a high level umbrella of what is possible. There's a whole load of things are possible. Of the possible options, some of them will be feasible. You narrow it down, and from the feasible options, there'll be some that are practicable, and of those, there'll be the best practicable option. Now, the plan doesn't direct the applicant to undertake the best practicable option, but in the context of the other policy we talked about around giving priority to avoiding effects, thought that was important. So in this case, say it's somewhat hypothetical, but say a possible alternative is trucking this material away. That is possible. You can drive trucks to the site, pump the water, take it to somewhere else that's licensed to receive it. And all we were given was a number that's going to cost this amount of money. So therefore, it's been discounted. I think what I meant by having a more comprehensive assessment was to actually show that working, show the homework that shows how that cost was arrived at, and other possible alternatives as well, like moving the liquid by train. We've seen this week, tankers travelling by train past through Greymouth. What's the cost of doing that, and whether that alternative avoids the types of risks that we've been talking about for the last 2 days. And then as a decision maker, you're not left with the conundrum of having to make this decision that creates these risks. Whereas instead, you'd be able to look and go like, well, look, there's other options that low risk or very, very much lower risks. So I thought that's useful context that I think is not present. It's not a barrier to granting the consent, but the Act says you have to have regard to those alternatives. The final thing I wanted to talk about was the idea of treatment of the water on site. So it struck me as a non-technical person, but we spent a lot of time talking about the uncertainties in the hydrological frame, in the hydrogeology around attenuation and direction of flow and where this water is going to go. That only matters if the water is contaminated. If this was pure water, we wouldn't be having any of this discussion, right? There'd be a discussion around the ecological effects of increasing flow somewhere. But so although I've said in the report that I think consent should be declined, I think there is a pathway to granting it, and I think that is a change to the proposal that provides treatment of the water on site and testing before it's discharged to a level where the questions arising about contamination of the drinking water supply, where it takes that off the table. That it doesn't matter where the water goes because it's not contaminated. You know it's not contaminated because you know you've treated it, you've monitored it and tested it before it's discharged. Now that's not what's proposed, but from my mind that would remove a lot of it would make the debate we've been having around the hydrology of the site, it would render that, put that in the background. It wouldn't be that important anymore.
But that would only be feasible, that option, if treatment was effective for the contaminant suite that was there.
Correct. And there's no evidence on that. I guess I'm just trying to leave a door open. I've said my recommendation is to refuse consent. And that leaves the applicant with ponds and bladders full of water and nowhere to put them. Yeah. But I think that there is a chance if there is such a device or a treatment train of some description that could provide that treatment. And granted, we don't even know what contaminants are in the water at the moment. Not all of them have been tested for. If they were tested and it was well constrained and well understood what they were, there's a treatment system that we know removes them to safe limits, then you've only got a hydrological question really over what's the effect in the surrounding environment. That'd be a door that's open to the applicant, but they haven't proposed that at this stage. I just thought maybe it's helpful to put that out there.
Civil problem, duration and those sorts of things.
Yeah, that's right. But my understanding from the technical evidence is that treats some contaminants not all of them, and some of them aren't known whether they're present or not. But the suggestion is, like, for example, with PFAS, it probably will be, considering what's been received into the pond. Now that matters, probably will be, from what I understood from.
I mean, this is difficult if you use that particular example. Treating them is prohibitively expensive, challenging for everyone that faces it. Some of the other compounds straightforward to treat, and in fact, there's some trials being undertaken for that. But you know, if you use the example that we have been looking at, probably something more impossible in that context, because it's very difficult to do anywhere. That's the practical issue.
Right.
But if it's not present, then it's not.
That's right. So I mean, from a planning perspective, then what would have been helpful for me in forming my opinion is whether the material is, whether there's contaminants in the water or not. If they are, what's the are there any alternative options that include treating it and removing it? And what's the thing with that? How much does it cost? And then you can say, well, look, actually, discharging this and risking contamination of the water supply is really the only thing we can do. And maybe that's true, but there's no evidence from the applicant that that is the case at the moment. Yeah. So that would, to my mind, that would help my assessment and help you making a decision where you can say, well, look, here's what's possible to do otherwise, but it costs $100 or it costs whatever it is. So therefore, can't be done. That's not in front of you. Yeah. Yeah. So that's what I had in my notes. Quite happy to answer any other questions.
Okay, had those discussions through this process.
Would you like a written statement of any sort? Or?
Yeah, just a transcript, which won't be difficult. We'll get a transcript that would be
Quite happy with that.
Yeah, rather than us, rather than me the accurate transcription, etc. Or even if at the very minimum, perhaps an identification on the recording as to who spoke when.
I think Thank you. That's good. Again, apologies for not picking up the summary, but
all right. Thank you very much for that presentation. Thank you. Yeah. We too now. From I mean, do you want to start? You want to formulate next steps now, or do you want to think about it?
We maybe just have a quick discussion now, and then maybe have a break and try the conversation. Because I've just sort of thinking in terms of, yes, I was thinking today. So we've got to think of top today. I think we want to discuss through. I don't want to keep you here any longer than you have to be here. But I think in terms of the reply, obviously, if we're going to leave it just standard or just reply, then do it right. But I think we've already suggested that we go further than that. I think probably the options essentially either adjourn for just a reply, in which case we'd have some time for some further investigations and some further conferencing and conferencing with the experts to come up with the conditions and plans to move forward with. Or it could be a more general sort of adjournment to allow other people to actually have some comment back on those as well. So in other words, an adjournment just for time to discuss, then we'll just put our reply in and go with that. Or basically have a bit more of an informed process. I guess the one thing that sort of keeps us still up at night is the actual state of the ground in terms of what's actually there already, and that we don't want to be delaying things longer than absolutely necessary. So I was kind of thinking whether or not a kind of a staged approach would be we maybe adjourn for 1 month, and in that time we'd see what we can achieve in terms of investigations and caucusing, and then report back to you in a joint form if we can. If at that point we've succeeded enough and we can finalise our reply on an agreed basis, or even on a basis of agreement plus with some disagreements that are manageable and you can use in your decision making, then we could do that then. Or if we need a little bit of time, we can ask for a little bit more time at that stage. I mean, I don't know if 3 months is necessary. That seems,
That's not going to work.
and I don't think it's going to work. No. So I mean, I think if we aim for sort of 1 month to achieve what we can, I mean, in terms of my understanding from our experts is that they have a form of condition, at least, which is along the framework that you've already established, which looks at the objectives, the parameters, the trigger points, and what actually needs to happen in terms of action plans. So then there's the actual monitoring plan itself, which would go with that. And our hope would be to be able to finalise that and have that for you before you make a decision as well. So that would be the ideal. If there needs to be a certification process that comes out of your decision instead, if that can't be finalised in the time, in other words, leaving that draft until something else happens. So that would be more the adaptive side of things as opposed to the actual condition, which is not going to be adaptive at all. And that's how I see it. So your condition does not include an adaptive approach. It actually sets what needs to happen and what must happen. The adaptation or anything that happens comes in the management plan later, which has to accord with those conditions.
The thing we'd need to try too is that the parties who wish to be involved have that opportunity.
Absolutely. Bare attention.
Yeah, I'm sure it would be, because that's the only one actually everyone is involved. We've also got working days, which I would hope we would get
the applicant will consent to the extension that's required to make this work.
Yeah,
absolutely.
Indeed. Okay, and then I just with how the end of my year is, essentially I want to get this decision out. I don't want to we just want to delay it necessarily. So the nearest we can get within that 1 month to having matters addressed and potentially reply
prepared,
following it prepared, then that works for me.
Yeah.
Okay. And a little bit of flexibility, obviously, but it's just the my commitments. I don't want to get into that situation where we end up having with just delay or
and that would be cancelled. That
no, indeed,
so that's the reality of the situation. I guess in terms of obviously there's some additional monitoring and actual testing that has to be done initially in any event in terms of those other contaminants, but from my understanding, it is still a finite list of what we need to actually test for, in addition to what we already have been testing, because we have been testing for everything that's obviously required by the existing consent, and some other things as well. So that there's a lot of other data there that we can rely on, can look to at least, and then seek to add to with the matters of concern that have been raised during the hearing. So I don't think that's insurmountable. In terms of getting actually draft plans so we can start discussions, we'd be hoping to have those to the other parties next week, at the latest, sort of between Wednesday and Friday. But that's just depending on people's availability to it. We'll have some draft that we actually start talking to. That puts some ideas around what actually needs to happen. NGO are already working on a bit of an action plan in terms of some of the other matters that have arisen. And so we'll be able to also advise the partners what those are like as well. And I think it needs to be said that these are reactions to the information we've had. I don't think there's ever been an intention to undersell the concerns that people have about the record of supply, and we know that we have to respond to that. I think the overwhelming feeling for the experts remains that the risks are extremely low, but we understand that there are the potential for risks, and if we can reduce them further, then that's what we need to do.
Okay, and that all sounds very sensible, that approach. I wonder if you would be able to put that in a minute, if it's joint minute ideally, but otherwise not. And then we can just a brief one, just essentially setting out what not
Sure.
discussed. I think that's appropriate time to, and a good way forward. Yeah, and
And I guess that the other thing is that the efforts from TRPL to look at further treatment options is ongoing. It's at the moment, and you've obviously seen the plant that's already on site, and there are further investigations going with what other options there are out there to assist that. And obviously that feeds into what Michael was talking about before as well, in terms of if we can get it to the level that it needs to be at. And that includes looking at all those other options as well, in terms of if there are these other contaminants there in any quantity at all, we have to deal with those.
So maybe it's helpful if Mr. Scott sets up a program of work as a proposal, puts that in front of you and it's circulated, and then the other parties get an opportunity to comment on that.
yeah,
Issue a minute, maybe.
that's fine, but I indicate again that those timeframes are that this can't just drift on. And I'm not suggesting you suggest
No, not at all. I was just thinking of it's going to be a time of various parties to be involved.
Yeah, representative for still here, and the people from the Grey District still here. We can even have to sit down now, just have a quick talk about that rather than weeks long. What I need to look like. Or do you want me to set something up?
Then it'd be better if you set it up. Like.
Yep, I can do that too.
You have any comments? Judy.
I think it would be quite good for us to have an adjournment so we can discuss it with our client. I think there's merit in both what Michael and Andrew have just suggested, and whether we can actually have a bit of certainty today would be useful, but I think it would be useful to have an adjournment now so that we can take instructions.
I think that I'm happy to do that if it's needed, but are you happy with that process on, do you need instructions to engage in that process? And see if you can nod. You need instruction, you know.
Yeah, we would like.
All right, okay. All right, listen, I'll give it 10 minutes. That's we'll have a quick break for back at 3:30.
Appreciate it. Well, you're in deep break.
Do you want to report?
Thank you, commissioners, for allowing to take instructions. Where we have come to is that Grey District Council would appreciate seeing a written proposal or a written plan about what it is intended to be achieved within this 1 month period, as Dr. Durant suggests. We have spoken to Ms. O'Rourke from Tonkin and Taylor, and we just do flag that it does seem there is genuine risk that we could be in the same position in 1 month's time as we are in today. It seems certainly that sampling of the surface of the discharge material can be achieved in a timely way. That could be done in a matter of days. But when it comes to the placement and distribution of new monitoring wells, that is going to take time, because there needs to be discussion, first of all, on where they are to go, where are the right locations to take representative data from. Then it takes time to construct them. I'm told that it's 1 to 2 weeks. The well development process requires about a week to pass before they are used. And then if samples are to be taken, turnaround time, it seems, is at least a week. So it seems we'll have information on the discharge sampling, but perhaps not too much more. So we just raise that in terms of the timing and the wish that has been expressed to move things along promptly. But as I say, there is a request to see that proposal in terms of the work programme in writing, and we can comment further then. And Grey District Council would appreciate the opportunity to be involved in this discussion.
Oh, you're perfectly entitled to. All submitters are. That's a given. But I also don't want to complicate what this process is talking about now. That what we're trying to do now is just establish I mean, the parties can do it without us, establish what will work for them, and then come back to us. But I'm signaling quite clearly that I cannot do a 3-month delay. And I don't think that's appropriate in the circumstances at all. It's been around for, let's be brought to a conclusion one way or the other. Okay.
If I can just add to that too, we've consulted as well. So just the regional council would just like to have, thought it would be quite quick to do, just input into the matters in the work programme, just to make sure that we've had input so that the concerns are going to be addressed by the.
Absolutely. So I've had a discussion with Mr. Griffith already, and the NGO are working on that work programme and what it's going to be. So I should have that certainly by tomorrow. So I can just read that and get everyone taking a look, and then provide some input. If you can get it back to me, then I can include that in the memo to you. Sort of around the loop, and hopefully on and get the information that we need to get.
I should be back in the office tomorrow, so I'll be able to respond properly as well.
I just know Ms. Bessie may wish to comment.
Did you have any comment, Ms. Bessie?
Yes, hello, can you hear me?
I can indeed.
Yeah. The submitter's position remains as what was set out in the submissions yesterday, that there is so much scientific uncertainty and gaps in information that the consent should be declined as set out in the submission. So it won't be able to participate in that process. It doesn't have any experts to contribute. It thinks that the process is defective. So I've pretty much said what I need to say. So in the submitter's opinion, the adjournment should not be granted. The Commissioner should proceed to decide the application based on the current information.
All right, thank you.
Thank you for the opportunity to comment again, and apologies earlier for the interruption. I thought I was on mute.
We thought that might be the situation.
So can we just confirm also though that whether or not Ms. BCA would still like to receive the papers that we're going to be circulating?
Did you hear that from Council?
Yes, I did.
Whether or not you'd still like to receive the papers that are circulating?
Yes, please. Thank you.
Yeah, absolutely. Because we're not wanting to shut anybody up out of this process at all. But I mean, obviously, experts will be involved, but we're not shutting anybody out.
Understood.
All right. Okay. Thank you for that. Thank you for that.
Thank you.
No, I think if we can get a memo from you tomorrow, and we get to respond tomorrow,
Yeah, I mean, obviously, it depends on,
or Monday.
yeah, when I get the work program, just do that immediately, and if you can get back to me as soon as you can, and try to keep the process as timely as possible.
Okay, and yeah, that'll include a reply on that too, in terms of when timing for that.
Yes.
Yeah. One of the things, just to sort of, whether I picked it up correctly or incorrectly, was yesterday there seemed to be discussions that were getting quite close to a condition precedent almost.
Yes.
Yeah, and is that?
Again, I think we're probably going to need to discuss how, and perhaps with the certainly with the planners, what that might be. Because I can still see there being a need for potentially some additional work that creates that state of there. And as I've set out in my submissions, I don't see that as any principle anything wrong with that.
No.
And perhaps more, it's about framing the condition whereby we allow for the commencement of the actual discharge. As opposed to the actual grant of consent.
Yeah.
So a different date for that, which means that it does not actually commence until that work has actually been completed. That would be the framing of that. If it's still required, and that if we get feedback that additional work is actually required, and still can't satisfy the concerns, then we'll have to see whether we need to go down that line. The extra month may avoid some of that. May not avoid it entirely.
All right. Anything else? So to the discussion. Okay. Well, we'll adjourn. And thanks to all participants. It's been my directions in terms of courtesy, etc., have been followed meticulously, and we've been well informed by the experts from and counsel from all parties. So I appreciate it. And we'll adjourn, and I will respond to your memo when we see.
Thank you.
Thank you.